May I seek your lordships kindly to mention one matter, my lord. My lord, this is in connection with item number 54 of your lordship's daily list. My
Yes.
lord, since last week, this matter has been appearing in your lordship's list. My lord, earlier this was appearing in the cause list of court number 238. Now, my lord, there's just one thing I wanted to draw your lordship's attention to. Your lordship will kindly have a look at this order. This matter has been
Item number?
54.
Item number 54. Okay. Group 2 matters.
Yes. Well, this matter had been substantially argued before Justice Chandu. Well, the petitioner had concluded submissions, well, that is recorded in the order.
Parted matter.
It's a parted matter. Well. I just wanted to bring that to your lordship's notice, well, because it is recorded over here that Mr. Joydeep Kaur, learned senior advocate, concludes his submission on behalf of the petitioner. Well, we were directed to file a written submission along with the compilation. Well, that also stands filed. They had just started their submissions. This is something I wanted to bring to your lordship's notice.
So it should be released.
I leave that to your lordship.
No, very well. So you are for the petition.
I am for the petition.
You are for the respondent. So it need to be released. Okay, please take down. Item number 54.
54.
The petitioner and the opposite parties are present. It appears that the matter is a parted matter before the concerned bench, and the argument yet to be heard. Considering the same, the matter being a parted matter, be released from the list of this court. Parties are at liberty to mention the matter before the appropriate bench.
Yes.
Item number 50. So,
Grateful.
yes. $54. Kumkum Bhattacharjee versus Vishwabharati University. পাঠার নেই কিন্তু ওটা হিয়ারিং হয়েছে লেখা আছে।
My lord.
Yes.
My lord, may I have your lordships kindly to mention that yesterday's matter, my lord. My lord has fixed that matter Friday week.
Friday week.
No, my lord, Friday week I have already a 2 o'clock matter fixed before another honorable judge. Can I come back this Friday, my lord?
This Friday I will not be there. I will be in the Bhopal.
Oh. Then, my lord, on that day I'll be requesting for 2 more days. Then Tuesday week, my lord.
Come on on that.
On that day. I'm just informing.
Yes.
Okay.
There is correction that in the name of the applicant.
What correction?
The name would be corrected. Nothing. Dalena.
Dolena.
Either Dalena.
No, what is the proper spelling?
Dalena.
Give me the spelling. Dalena. not DO.
And that is Khatun will be expanded.
What?
Khatun will be expanded. Only the Dalena. There will be no Khatun. In terms of the order passed by you, we have corrected. That's memo that that order was passed on 1st September.
1st September.
Yes. Corrected in the memo of habit, but last in the presentation from since last year there is last Dolena Khatun. That is last.
No, 1st September is the order.
Order was passed.
Yes.
Yes.
The final order was passed.
Final order. On earlier and before 1st September last year,
Before 1st
the order we have corrected. It would be last Dalena instead of Dolena Khatun.
Dolena Khatun was the original name.
Thus, it would be changed. Dalena. Thus, our order identity card. Thus, there is going to Dalena. Only Dalena. No Khatun there.
Whether you have preferred any can.
Thus, no, thus, we do not find any can application.
So I am not finding any order. Where is the order? Regarding the correction name of Dolena. Appellant is name of the appellant is.
So in the memo of applicant, we have
Yes.
corrected last.
No.
In terms of the first, in terms of the
In
order.
terms
passed
of
by
the order
Thus,
on 29/8/2020.
thus, it is only Dalena. No Khatun and thus instead of Dolena.
So what you want for correction? In the impugned order,
In the
final order.
final order.
Final order, it was written Dolena and others.
Dolena and others.
It should be Dalena and others. Okay. Very good. Please take down. The matter appears for correction. The name of the appellant was written in the order dated 1st of September 2023 as Dolena. Dolena. It should be read as Dalena. Dalena.
Dalena.
Next. Yes. Mr. Shah, what is it? What is for correction?
Definitely, see the case I make you 1160/2040. But I have mentioned the first page 5. Page 5 order sheet FMA, it will be FMA 1160. Order has been passed, FMAT 116/2014, my lord.
Okay, I understand.
Next point, my lord. Even the requisite code fee, my lord, you can mention the order sheet. Page 4 last paragraph. Order sheet.
Subject to ascertainment of payment of requisite court fee.
Yes, my lord. In even page 1, I claimed 9 lakhs before the tribunal court in here. I already paid 9,000. It's the one, my lord. You can see, my lord. So no dues are there. Excess court fee already paid. Because the work report and original memo have been issued from the High Court. This is the document. Original work report called for and original memo appeal already missing. This is the secondary memo appeal, my lord. So I cannot any document show from the lower court report.
Okay, CF paid is correct. What is your claim?
9 lakh,
Claim was
Yes.
9 lakh.
yes, page 4 is good. Page 4, you can see, my lord,
And what was the award here?
8 lakh,
8
total
lakh,
award, 8 lakh something.
100 to 250, 1,250.
Page 4, 9 lakh claim, my lord.
Very well.
100,
Okay.
paid only 8 lakh, 1,000, 2,500, 8 lakh something award first. So I have paid the excess court fee, my lord.
This matter appear for correction. It appears that in page 4 of the order dated 6/9/2023, the nomenclature of the appeal was erroneously mentioned as FMA. It should be read as FMAT. Stop. Next paragraph. The claimant has referred the claim application before the learned tribunal, praying for compensation amounting to rupees 9 lakh. The court fee has already been paid, amounting to rupees 9,000. This court awarded a sum of rupees 8,01,250 towards the compensation. So at this juncture, the requisite court fee is not required to be paid first. Let a copy of this one.
All items are closed. 3, 5. My lord, and insofar is the Suchitapal, he informed me just pass over. So you get the court.
Okay. Pass it over.
6, 7.
A short question.
Right.
7 miller RAM. 7 miller RAM 40.
Which for the appellant?
The applicant not adhered to the on the last occasion that for Justice Subhashrandi on then that 12th April, Miller we have also adhered Miller, the applicant not adhered, and Miller administrative notice was directed to start.
Give me the papers. Let me see what is the report of administrative.
That they are not interested in happy. We are happy with the time praying for this. The long fasting happy with the 2009.
Okay. তারপর process করি মারা গেছে please take down the Union of India is represented through learned advocate. Give your name. Stop. It appears that the incident matter was appeared on the earlier occasion and in absence of the appellant, a departmental an administrative notice was served upon the appellant. Stop. It is reported by the department that the registered consignment was returned with endorsement deceased. Stop. Peruse the registered consignment. It appears that the present appellant is not turning up for few days, for long days, and it is reported by the postal authority that the appellant has died. Considering the same, the instant appeal being infructuous, and it is ordered that instant appeal be at the same dismissed from the court. In order to stay passed by this court, independence of the instant appeal is hereby also granted. Connected pending applications are offered also.
My lord, in this matter, I am for the respondent. Mr. Shoidur Rahman is appearing on behalf of the appellant.
Yes. That is Mr. Rahman.
Yes, my lord, we have only received the notice, other preparation of paper book and other direction may be given.
Have you received the paper book?
No, my lord.
You just wait. I am just passing it over.
Lordship.
Pass it over. Next.
Short pass.
In which matter
11 12
you are appearing?
for appeal.
Do you know who is for the insurance company? Very well. Pass it over.
17, 18, 19, 20, 21.
Mr. Bhumi, you are the appellant.
Yes.
Lal Mohan Ghosh is the respondent. Just for a while. Next.
22, 23, 24, 25, 26, and 27, 28, 29, 30 and 31, 32, 33, 34, 35 and 36, 37, 38, 39, 40 and 41, 42, 46, 44, 45, 46, 47, 48, 49. Second call. Number 4,
What? Which matter?
21.
Yes. Call 21.
Number 21.
কালকে বলে দিন। হেল্প করো। New India is the appellant. This is a minor death case. It is a minor death case. Minor was 6 to 7 years old. 166 application. On the grievances that matter, we have taken a specific plea and additional evidence is also filed that the concerned vehicle violate the policy in view of the affair. There is no valid driving license. It is a truck. She should have a heavy vehicle, motor vehicle, but LMD with the driver, and that was also brought on record. Would consider taken into account, but not discussed anything, and no pen recovery order was given, and other grievances not. It is a minor case, only 6 to 7 years old. So 1/3 deduction should also be given. Then usual all along usual given. It should come down. This is the only program. No, and 1/3 deduction was not made, not given. 15,000 should be considered, but 1/3 deduction. 15,000 is the annual income was given. Yes. Multiplier given 15. Yes. Why multiplier 15? Second schedule. Sarala holo 15. According to the Sarala Pharma, it would be 18. 15. 5 years, 6 years old. But 1/3 reaction was not made. That's why. Parents are the petitioners. Yes. Yes. I thought has not that possible. The High Court judge that first wants to keep all the practice because for the guidance also taken the income of the minor 30,000. No, this is not your appeal. This is the appeal of insurance company.
No,
No, no. Yes, that was the claimant appeal.
here,
But in the present appeal, it is
the new India.
referred by the insurance company. Maybe same, but how can this claim can be entertained, your claim, in the appeal? In the appeal of insurance company.
I have saved my life for amount my life, but tribunal awarded my life plus 25,000. No deduction. As per Honorable High Court,
No, civil deduction was always there. 1/3 deduction for every.
Won't you think that, won't you giving judgment also there?
One and stake is a decision, 1 or 2 cases not deducted. Otherwise, it is 150 to 180. This is by Honorable Supreme Court. But this is a minor case. Out of say only say 6 or 7 years old. Other minors is all 14 years, 15 years, student of
Judgment would only drop the basis of judgment, tribunal awarded by the 2,25,000.
সেটি 1/3 deduction করে। রাখবো না, টাকা ফেরত দিয়ে দাও। Yes, তুমি টাকা পাবে। বাকি কিছু টাকা। ঠিক আছে?
Yes, no deduction.
And simple receipt judgment
Only 15,000 is the income per annum was adopted and no deduction was made.
current judgment by
ওরা এজটা দেখ।
In this case, it is age of 13,
above 10 একরকম,
age of 12 years.
above 10 5, 6 years old.
Multiplier applied 15. Notional income taken 15,000.
Planning 160.
Multiplier will be 20 as per Sharonda Dharma. On the basis whether the judgment passed by what was the best reverse for tonight.
No, in all Supreme Court cases, the multiplier was adopted 15. In the death cases, you have referred.
Case whether
Yes, Meena Devi, it was 15,000. Multiplier is taken 15.
One judgment 160 also multiple.
No, it is not your appeal. If you preferred any appeal,
On the basis of petition company, I will entitle 2,25,000.
what was the award?
2,25,000.
2,25,000 is the award.
Yes, ma'am.
So your ground is for deduction on
On
personal
deduction.
expenses and pay and recovery.
Pay and-
I just said whether research judgment whether case whether the minor death Supreme Court order 6 lakhs. Recent judgment.
So you
Yes,
have to
sir.
prefer an appeal to the effect, otherwise
Accident
how can
by-
I entertain you?
accident by law 94.
What is the age?
3 years old.
3 years.
Younger than this different.
3 years.
Yes. It's a Supreme Court judge.
Enough.
Usually they take mercy.
State is
Supreme Court.
the Supreme Court.
This is the appeal before the Supreme Court by the claimant.
Yes, sir.
You have not preferred any cross appeal or appeal otherwise. So how can your claim can
I
be
thought,
enhanced?
my lord, not high politics, I am expecting,
Yes, that you can
I
ask.
am also effective high brother, plus interest.
Yes, interest you can enter.
Yes, sir.
Interest you can enter.
Effective plus 55.
Very well, very well, very well, very well. Hard. Please take down. Yes, Mr. Bhumik, anything to say?
No, I can also cite also, well, decision of Supreme Court.
Yes,
Now, 1,80,000, 1,53,000. Now, since they have not filed any cross appeal or cross application, amount cannot be augmented. And so, but that is also admitted amount where there is violation of policy, terms of policy. So I have a right as per the Baljit count that should be recovered.
very,
And amount should be
very.
reduced. And I
Okay,
think your lordship, my learned not so let it allow 2,25,000 be
very, yes.
yeah, 25,000 be returned to the company. Actually, and
The instant
let it
appeal is
2 lakhs given to the
very, instant appeal is preferred
2 lakh
against
Right.
the order dated 20th day of June 2013, passed by the learned judge Motor Action Tribunal, 11th Court, Alipur in MSC case number 364 of 2007. The instant appeal is preferred by the insurance company. Stop. The brief fact of the case is that the present claimants, present respondents, being the claimant, preferred an application before the learned tribunal under section 166 of India for getting compensation on the ground that their minor child was died in a road traffic accident due to rash and negligent driving of the driver of the offending vehicle duly insured under the policy of the insurance company. The learned tribunal has heard the matter in presence of the insurance company. Stop. The owner did not turn up, thus the order was passed ex parte against the owner. The learned tribunal has awarded a sum of rupees 2,25,000 along with 6% interest per annum from the date of filing of the claim application. Stop. Being agreed by and dissatisfied with the said order, the present appeal has been referred by the insurance company. The insurance company has only 2 grounds before this appeal. Firstly, the learned advocate for the insurance company submits that the offending vehicle was a heavy vehicle. Stop. The driver of the offending vehicle was not possessed the required driving license to ply the vehicle. The police paper proved the fact before the learned tribunal. Stop. The learned tribunal has observed the same in the impugned judgment, but the order of pay and recovery has not been made in this case. Learned advocate for the appellant submits that the insurance company do not have the liability to pay the compensation as the terms of the policy has been violated by the owner. At this juncture, the owner may be directed to pay the compensation. He further, the secondly, next protocol. Secondly, they argued that the deduction towards the personal expenses, that is 1/3 of the fixed income, was not made by the learned tribunal. So the award should cost after deducting the personal expenses of the deceased. Learned advocate for the claimant respondent submits that by virtue of the decision of the Honorable Apex Court, the insurance company have entitled to get an order of pay and recovery. Stop. The respondent also argued that in the minor aged about 6 years was died in a road traffic accident. 7 years ago. In this case, the Honorable Supreme Court was very much clear that the deduction towards the personal expenses in case of minor cannot be made. Stop. In support of his contention, he cited decision of Honorable Supreme Court passed in Monju Devi and others versus Musafir, Paswan and another. 2005 within bracket 1 PSC 609 within bracket Supreme Court. He also cited Meena Devi versus Nanu Chand Mahato 2022 within bracket 4 PSC 371 within bracket Supreme Court. Heard the learned advocates peruse the observation of Honorable Apex Court in case of death of minor in a road traffic accident. In both the cases, it appears that the Honorable Apex Court has considered that the minor being a non-earning person, a sum of rupees 15,000 must be taken as income, and no deduction has been made in those cases towards the personal expenses. Considering the observation of the Honorable Apex Court, it appears to me that the learned tribunal has committed no error for not deducting the personal expenses of the deceased in this case. Next, in considering the plea of the insurance company, it appears that the driver had no valid driving license to drive the heavy vehicle at the time of accident. Thus, the insurance company legally not liable, is not legally liable to pay the compensation. Pay the compensation in this case. By virtue of decision of Honorable Supreme Court passed in Saran Singh as well as Baljit Kaur, it appears to me that the insurance company may have an order of pay and recovery. Thus, in this case, the insurance company is directed to pay the compensation to the claimant, and in turn, they are at liberty to recover the same from the owner of the offending vehicle, according to the principle laid down by the Honorable Supreme Court, passed in Baljit Kaur. Stop. It appears to me that the award passed in favor of the claimants to the tune of rupees 2,25,000. I find no infirmity in such compensation. Thus, the insurance company is directed to pay the compensation amounting to rupees 2,25,000 along with 6% interest per annum from the date of filing of this claim application. That is from. Okay, I'll put it. 14th of November 2007. 14th of November 2007. Within 8 weeks from the date of passing of this order, with the office of the London Registrar and High Court Cabinet. Stop. Then Registrar General High Court Cabinet. On such payment, the office of the London Registrar General High Court Calcutta shall disburse the same by 2 equal account pay checks in the name of the claimant respondents. Stop. After such payment, the insurance company is at liberty to recover the same from the owner of the vehicle according to the guideline laid down by the Honorable Supreme Court in Baljit Kaur as well as in the Saran Singh. Stop. FMA 3387/2013 is disposed. Can applications. For the list, second time.
Number 5 is lost.
8.
Number 5. Both are present.
What is list?
In which matter?
Number 5 minus.
Number 5. Yes, yes.
I'm appearing on behalf of Appellant Insurance Company, Lordship. It's a changed brief, but I'll try to assist my Lordship.
Yes.
This is an accident of Lordship, 2004. And
Give me a paper book.
yes, it was. ঠিক আছে, যেটা আছে ঠিক আছে। Lordship, this is one informal paper book my learned friend had prepared. Since I did not have the documents, Lordship, I had applied for the certified copy. I've received some of them, but not all of them. But the LCR is there before my Lordship.
Nice.
So I have preferred appeal, Lordship, on the point of non-involvement. Non-involvement. One Moina Bibi, she died, Lordship. She was alleged to be a vegetable seller, and the minor son of the deceased, Lordship, filed the claim case.
Yes.
So
Award was claim case under
this is 163A, Lordship. Yes, an award of rupees 3 lakh was passed. Learned tribunal assessed the compensation on the basis of 3,000 rupees per month. 1/3 was deducted. 16 multiplier was adopted, and claimants, of course, they award was of rupees 3,84,000, but it was restricted to rupees 3 lakh because the claim was of 3 lakh.
Okay.
Now, Lordship, will kindly come to my memorandum of appeal.
Yes.
Yes, it is at
Page 23.
page 23. Lordship. So, from my memorandum of appeal, Lordship, paragraph 2, 3, Lordship, 4,
Yes.
5, Lordship will find that I have preferred the appeal on the point of non-involvement. The accident took place, Lordship, on 28th of July, 2004, Lordship. And the FIR is there in the paper book. just after the claim application, Lordship, the FIR. Just after the claim application, Lordship, at the beginning.
Yes.
Yes. The accident took place on 28th of July 2004, Lordship. And my lord will find from the FIR, Lordship, that it is against a truck. The FIR was lodged, Lordship, on 13th of September 2004.
Truck bearing number.
Yes.
WMH1143.
Yes. So accident on 28/7/2004, that is 28th of July. And FIR was lodged on 13th of September 2004 against one truck. Now, Lordship, in the post-mortem report, Lordship, post-mortem is just after the insurance policy, Lordship, the post-mortem report. My lord will find
Yes.
that the post-mortem report mentions about one Tata Sumo. It is in the column, it's on the right-hand side, information furnished by police. Has my lord found that column? Yes. Due by a Tata Sumo.
Being knocked by the
Tata Sumo. The post-mortem, Lordship, victim subsequently died on 5th of August. Accident took place on 28th of July and victim died subsequently on 5th of August, and post-mortem was done on 5th of August, and it says Tata Sumo. So this raises doubt. And most importantly, Lordship, it's since the FIR, it was delayed. It was on 13th of September.
Yes.
So as per my version, Lordship, it was implanted. Except the FIR, Lordship, and since the post-mortem, Lordship, it was done on 5th August, I rely on the post-mortem report which says the Tata Sumo. And suddenly in the FIR, Lordship, this Tata Sumo probably did not have a valid insurance policy or something. Then it was changed to a truck. This is my sole contention. And regarding the relationship between the victim, the claimant number 1, Lordship, he says that he was the uncle of the victim. So he was the brother of the deceased. But
Claimant number.
claimant number 1, this yes, yes. Fakir Malik, he was represented.
Represented on behalf of.
Yes.
Only minus or a direct minor.
Yes.
Only minus or a
এক মিনিট Sorry. So he was the uncle, but no document has been produced to prove the relationship between the victim and claimant number 1. No document. So how he was, whether he was at all the uncle or not, Lordship, this has not been proved in accordance with law. And it was not dealt with, Lordship, in the judgment also, in the award passed by the learned tribunal, Lordship. If I am not wrong, it was also not dealt with properly. The judgment is, Lordship, it's in the last, Lordship. Actually, my paper book, it's not marked. The page numbers are not there.
Right.
Lordship will kindly pardon me, Lordship.
So whether the issue of
Yes.
non-involvement of the vehicle was dealt with.
No. No.
Issue has been framed, minor.
Has it been dealt with? Dealt
Issue
with?
has been.
Yes. I'm sorry, Lordship. At
Yeah.
internal page 5 of the award, Lordship will find internal page 5. Internal page 5.
Yes.
The first paragraph.
Yes.
So from the above, I find that PW2 has fully supported the version of petitioner The claim of the petitioner also finds support from the post-mortem report, which shows that the death of the victim was due to the effects of head injury, which was ante-mortem in nature, and that the victim was knocked down by Tata Sumo on 28/7/2004 at about 9:30 p.m. And the victim expired on 4/8/2004. From the copy of insurance policy, I find that the said vehicle was under cover of insurance at the relevant point of time. But I stop here, Lordship. Insurance policy says Tata diesel vehicle truck. And then Lordship will see. I'll just read. From the copy of insurance policy, I find that the said vehicle was under cover of insurance at the relevant point of time. So going from the above, there leaves no room for doubt in concluding that the death of the victim was due to the effects of the injuries caused by the motor vehicle accident due to rash and negligent driving by the driver of truck number such and such. Suddenly the Tata Sumo, it becomes truck. And the said vehicle was under cover of insurance. This is very confusing for me also, this paragraph. But it proves that the truck was not involved.
Yes.
And regarding that relationship, as I was saying, at the last Lordship, page 7, the account pay check, it's in the ordering portion, page 7, the account pay check was directed to be issued in the name of the uncle. No relationship was proved. Has my lord found it in the middle portion, account pay check in his name through this tribunal within 60 days from this date, failing which the award shall carry. Petitioner Fakir Malik, on receipt of the check deposited by Opiato, shall keep the same with any nationalized bank in short-term fixed deposit in the name of minor Malik. We do not even know whether it was the uncle or not. And now, whether the son of the victim will at all get the check, this entire thing is extremely fishy. And that paragraph itself is very confusing, which says about the vehicle, Lordship. This is my entire case. And PW2 is one, Sadre Alam Malik. If the chart sheet is there in the LCR, Lordship may kindly see if his name appears in the witness list of the chart sheet. One Sadre Alam Malik.
Sadre Alam Malik is the de facto complainant. That is the FIR maker.
Yes, and he is also PW2.
He is also PW2.
Two, but the FIR was lodged on 13th of September.
Yes.
So can his evidence be relied upon at all? I have the copy of evidence with me, Lordship, of Sadre Alam.
Yes.
He says that Fakir Malik is my neighbor. I have not received any summon from the court. Fakir Malik has asked me to depose, that is the uncle, who itself is a fishy character, has asked me to depose in this case. The accident took place on 28/7/2004 on GT Road at Galsi Bazaar. Save and except the instant accident, I have seen other accidents also on the GT Road, but I cannot say the name of the vehicle and the name of the injured of the other accidents. It is not a fact that Fakir Malik is my relative. It is not a fact that I did not see. It is also not a fact that I have deposed falsely as per instruction of Fakir Malik. Around 50-60% assembled at the place of occurrence after accident. I cannot say their name. I took the injured to the hospital. It is not a fact that I have deposed falsely.
Yes.
Regarding Lordship, I also have the copy of evidence of PW1, who is Fakir Malik, the alleged uncle, Lordship. His cross-examination, Lordship, will kindly come to. It's not part of the paper book, but it's probably there in the LCR, Lordship.
Yes.
Yes, his cross-examination. He says, I have filed this claim application on behalf of minor child Milan Malik for the death of my sister Moina Bibi, mother of Milan Malik. Husband of Moina Bibi is now dead. He died prior to the death of Moina Bibi. Moina Bibi died on 28/7/2004. Father-in-law and mother-in-law of Moina Bibi are also dead. I have filed my affidavit in chief in which I have stated my age as 45 years. I shall not produce any papers to show my age. I have not filed any paper to show that Moina Bibi was aged about 35 years. It is not a fact that Moina Bibi was aged about 45 years at the time of her death. My sister used to carry on vegetable business. It is not a fact that my sister was not carrying on business. I have not filed any paper to show my sister was carrying on any business. Why I read this, Lordship? Deceased, she had nobody except the minor child. So it's a very convenient case. And he especially because Fakir Malik did not produce any document. No voter ID card, nothing to prove his relationship or his age or anything. He simply comes up and says that I am the uncle of the deceased, of the minor child. And in any event, Lordship, even learned tribunal recorded that the Tata Sumo was responsible for the accident. Suddenly, in the FIR written complaint, it becomes a truck, and also in the paragraphs below, Lordship, it became truck because the insurance policies of the truck. And in the FIR, it has been stated that the claimants, they were busy in the treatment of the deceased. She died on 5th of August. FIR was lodged on 13th of September.
Yes.
So the period between 5th of August and 13th of September is unexplained. The delay. Even the rituals, Lordship, it wouldn't take so much of time. But when implantation is there, this period is required to implant the vehicle. This is my case, Lordship.
Yes, Your Lordship. This is the 163A case, Your Lordship. This is the door is only closed. Only documents are requirements. FIR, PM report, nothing else. Even the charge has been filed. Delay FIR is not the criteria for dismiss the claims. So many rulings has there. Now the question arises on the case filed against the owner of insurance company, WMH lorry. Insurance company appear, file the detailed statement. Not a single word has been explained that not my vehicle not involved, Tata Suma was involved. Not a single word has been found. Even one can take a 170 MB Act, file the petition. I take defense on behalf of the owner. No defense has been created. Now produce any evidence owner they have not evidence. Even PW wants on the cross exhibition, not a question put that my vehicle is not involved, Tata Suma is involved. Not a, what is there. Even PW1 is the PW2 is the if I make an evidence here. No question has been proved by the insurance company. The TRP was FIR, it is false. Tata Suma is involved in the action. Not a single award is there. But only PM report has the mention. London Tribunal already mentioned the PM was made Tata Suma, but not clarify anyone on behalf of the insurance company that my vehicle is not involved with that, not at all involved. You are put that Tata Suma by getting the compensation. Police after investigation charges filed, only 168 showed limitations there. Similar rules have been passed by our courts there. Rita Samanta case, one is there, minor. FIR lodge, first FIR lodge that motorcycle does the standing in any ports, then one got involved. In the question, on the involved that year, the insurance company appeared and 170. Now the question arises by the London honorable courts. You are appear 170. Why not produce the owner of the case? Why not produce the driver in the case? Not involved in the accident. Your question changed. Why not produce the tribunal court? Why not produce the Lawan court is that? Say ruling is that, my lord. You have to know it. Even once another case is there. My sound lorry involved in action FIR lodge. But claimant file against the owner of the pass. Award is passed, my
The question is why PM report stated the number to be the.
Yes, yes, my lord. Not challenge the, this is the, clarify the person report, but not challenge the insurance company. Insurance not challenge, my vehicle not involved. Even the, our 160 charge has been submitted. Police has been submitted. Insurance company not produced, not involved, my vehicle is there. No evidence has been given. No, the driver is given now, my vehicle is not involved.
But your document, there is a police document says otherwise, contradictory documents are there.
Why got to document, my lord? Issue is framed. At the passing the judgment, my lord, you can say that 163A, issue has been framed. Framed against the owner of the image lorry, not to mention the issue of the frame status. Now the question is, that ruined the heading.
Let me see the final report of UD case number 670 of 2004. And the inquest. That would be proper.
Judgment, do it to the last one. Take it out. Go ahead. Go ahead. Just.
The question was raised for implantation of the vehicle. So why they utter otherwise before the tribunal? The driver, the owner. This is the case of implantation as pleaded by the insurance.
No, no, my lord, is the question is, the FIR lost the lorry, first claim on the first. Now the question arises,
Yes.
one involvement question is arise, my lord. Now the question is, if I lost the lorry, what claim is the owner of the vehicles? Is the sum of the same is there, my lord? Owner, the same is there, my lord. FIR unknown, just another vehicle, sorry, involved in a charge sheet, my lord. Now the question arises, my lord. Insurance company conceals the case here. She must produce the owner of the driver. She produce the driver, but no, my vehicle not involved in the accident. Now the question arises, my lord. If it is some of the already mentioned, you can take the 170 MV Act. So you take defense on behalf of the owner. You must prove that my vehicle is not involved in the accident. Now the question arises, my lord. It's some of the clearly mentioned. You can take the defense 170. So why not produce the owner and driver? My vehicle is not involved in the accident. In the case, chassis has been framed. 160A only limited scope is there. But insurance company, not any question arises because the driver that the Tata was involved in the accident. My vehicle not involved in the accident. Now the question arises, my lord. Not a single, even the doubtless. You can see the doubtless. You can see the company, no involvement that might have involvement, Tata Soma involvement. Now the question arises, my lord. Not a single award has been expressed that my because not involved in that.
Yes.
To compare United versus
Also there.
downtown.
United India Insurance Company versus Sunil Kumar.
I'm ready to watch.
Hey, Aja. See the symbol. আর what is the name?
আরে দাদা সাইটেশন গুলো দিন কোন কোন জাজমেন্ট দিচ্ছেন একটু বলুন।
What is this? For what?
168, my lord. This is the case is there. 168 case. This is a special legislation. No, only third party claim has been granted.
Yes,
No.
third party can are granted.
Now the
Whether only the question is
uh,
whether the vehicle was involved.
yes, my lord. This is a question tribunal has been confirmed.
How confirm? That is there.
Judgment has been passed.
No, tribunal was not clear about the finding.
No, my lord, judgment has been passed. Frame has been issued, my lord. Frame has been issued.
Issue has been framed but was not answered clearly. This is the appeal. In page 5.
Yes, my lord.
Which was antemortem in nature and the victim was knocked down by the Tata Sumo. It is observed by the tribunal but was not clear, but was not clarified why the truck was involved. How the truck was involved with that.
My lord, issue has been framed, my lord. Question is
Yes,
here.
issue has been framed, but it was not discussed properly. This is
What has
the,
been passed against
on
the
this the appeal was preferred.
Yes, my lord. But question is, my lord, any question has been put before the silent tribunal that Tata Sumo was involved in the accident, my because not involved. Not a question is there. Now the question arises. Insecurity take defense 170. Detailed statement filed. Not a single word has been explained, my lord. Now the question arises. If the insecurity was silent about the accident, in the insecurity about the silent about the accident, so what can I do by the claimant, my lord? I have filed the FIR charges there. Insecurity, not a single word has been expressed that my because was not involved, that is involved. Claimant has a limited scope is there, my lord. I FIR and charges has been submitted and we have submitted. Now the question arises, my lord. If the company has changed, given evidence, any dispute involved in the accident, then the question arises, my lord. Insecurity about the silent about the accident, my lord. Not a single word. Even the details, even not any potential evidence, even the PW1 not for us, that my because not involved.
Paragraph 6 of my written statement, it is there. I have
Yes,
taken the
yes.
plea.
Not
To determine the issue, some more police paper is required. I am passing order. Call for the reports. Please take down. The incident matter is heard in court. It appears that to for the determination of the issue involved in the appeal. Bar 1 PSUD case number. Stop. The final report of Bar 1 PSUD case number 670 of 2014, dated 5/8/2014, is required to be perused. Stop. It further appears that the another Golsi PS case number 115 of 2014, dated 13/4, 13/9/2004. 115 of 2004. Golsi PS case number 115 of 2004. 115 of 2004. Of 2004, dated 13/9/2004, under section 279/304A IPC was started on the basis of the same accident. Stop. The inquest report is required to be perused for the proper determination of the issue involved in this appeal. Accordingly, the the SP Purva Bardhan is directed to produce the final report of Part 1 PSUD case number 670/2004, dated 5/8/2004, and the CD of Golsi PS case number 115 of 2004, dated 13/9/2004. For this court on 27th of September. The SP must ascertain the production of inquest report of the deceased in connection with this case. Place the matter on 27th.
I'm deeply obliged, Your Worship.
The copy, the copy of the order be circulated upon the SP concerned to office of the London District and High Court Calcutta. Concerned department to do the info.
I'm great.
Kapasiti.
Mr. Bhomik is the appellant.
Not
This is a appeal arising out of an injury case. Award passed in injury case.
Yes.
Now, so for the award was a lump sum award, 4 lakhs was awarded. Now, nature of the injury was not confirmed, whether it is a permanent or temporary. That was also not confirmed. Although when one doctor opined that there is a 80% injury, there is an injury of fracture, and he has deposed that it is a deformity. Mere deformity is not specified in the act itself, or neither Motor Vehicle Act and Workman Compensation, nothing else. Unspecified injury, only on the ground he has opined that it is here. But whether it is a permanent or temporary, that is also not confirmed. However, the tribunal awarded a lump sum amount 4 lakhs. Initially, the claimant in his claim petition mentioned that I am a businessman. I was a businessman. I used to earn 4,000 per month. At the time of deposition, he has not placed any document as regards his business. I denied that I could not find. Someone else deposed on behalf of the claimant, and that on the deposition, he has said that I used to pay 3,000 per month as a salary. A person is claiming from in his averment that I am a businessman. Now somebody else come and I say that yes, I paid 3,000 per month as a salary. Now, what is the nature of business? He used to run the lottery ticket business. That was his case. Now, under this circumstance, that was our lump sum. I guess that we have come to your trusts. Now, main grievance, my lord, income was income. Next, there is no basis of finding the amount of 4 lakhs. There is another is 80% loss that cannot be, or whether it is a permanent or mere deformity.
When lump sum award was given,
Yes.
then there is no chance of anything.
Yes.
Any assessment of
Nothing.
No such structure formula was given.
Nothing.
Nothing was given. Only 4 lakh was given. So whether it was taken to be the 80% or 100%, there is nothing there.
No.
So lump sum amount was given, and you have preferred this appeal against that lump sum amount.
And also interest is 8% was given, in default 10%. That is also one of the ground that
Excess.
Excess amount, and penal interest cannot be given. Now, if you kindly come the evidence part. And initially, he has claimed one thing more. Initially, he has claimed 1 lakhs. Subsequently, he filed an application for amendment. That was turned down. Subsequently, after passing some years, he has filed another application for amendment that was allowed, and a claim was hiked. So, by this way, he has passed away some valuable time that so in that and got the benefit of it by interest.
Ultimately, what was his claim? 6,20,000.
Yes, but once it was
Initially was 1 lakh.
that was amendment was then the amendment was sought for, that was rejected.
Amendment was allowed and it was
Rejected. First it was rejected. Subsequently, some other judge came and filed another application that it was allowed.
then you have to file one civil revision against that.
But whatever, but this is the,
At
now
that
it is
time-
appeal.
At that time, that cannot be considered at the stage.
But-
This shall not be any issue here.
But the issue is that they, by this way he has
Enhance the claim. Enhance the claim.
wasted the time.
Okay,
so
wasted the
there is a
time, so
So I cannot
he is
be
not
able to pay
entitled to have
payment for
the,
that extended
the
period.
interest.
Yes, at least interest should not be paid to that extent.
Okay.
Now, page, Lord, I am placing the main portion. page 1, he has claimed that he is about to 25 years old. Has item number 3. Item number 4 is mentioned specifically the business. Number 4, name of address of the employer does not arise. Number 4, page 2.
So initially he stated his income business and ultimately he became a salaried person.
Yes. How
This is your claim.
So what is pleaded that does not prove. What is proved he has not pleaded. Now, accident was happened at 2005. Yes, he was a claim he was a passenger of a bus. All the treatments was done in the government hospital. This is the and 23. How the accident was happened and what is the injury was caused to him. On the basis of claim. Now, evidence similar is 19. Is 19. He himself deposed evidence. I gather the such. By occupation, unemployed. Religion Hindu, residing at such and such. Now,
You are referring page
19.
9.
Deposition 1919.
Yes.
The first part. Paragraph 4. I immediately after the accident, I took admission for medical treatment in Barwan Medical College and Hospital and was under treatment as indoor patient of the said doctor from 6/1/2005 to 10/3/2005 as outdoor patient of the said hospital and the doctors of Bahrampur Hospital and some of the 20 hours they already spent for the head of the medical expenses. There were operations on my hands for several times and it caused disfiguration of persons. Like disfiguration of physical disfiguration of persons. That the medical board of Bahrampur Hospital also examined me and they have declared my physical disablement 80%. That the accident caused the disablement of my both hands, which are bented besides other injuries. That due to the said accident injuries, I could not perform my duties and not lead my normal life. I am unable to act anything, especially eating, sleeping, wearing, writing in the that I lost my prospects. I received calls from the employment exchange for government service, but I am unable to attend the same due to my disablement. That at the time of accident, I was about 25 years. I was a businessman. I used to deal with the lottery ticket sale and commission agent of the stationery goods. That my monthly earning of 2,000, I was sole bread earner of the family. My family members are to engage themselves to look after my injuries. As I see now, page 22, the cross-examination. On 10 August 2006, I filed an evidence in the chief. I have stated correctly in my said affidavit in chief. I am the resident of organization of Barampur. The accident took place within the jurisdiction of Mongol Kota, subdivision Patwa Parwan. The said bus was very much crowded. There were other passengers of Baharampur with whom I was acquainted. The said accident took place due to driving speedily by the driver of the bus. As a result, front wheel of the said bus was detached from the bus, and the said bus fell down in the paddy field, and accident took place. Due to the accident, I lost my sense. I regained my sense at Bardwan Hospital on the same day after 2-3 hours. I cannot say the name of the passengers of the said bus. I admitted in Bardwan Hospital on 6th of January 2005, and also admitted for there 2.5 months. Dr. Chinmoy, they treated me at the said hospital. His name will reveal from the medical papers. He will also depose in this case. After discharge from hospital, I was treated as an outdoor patient at the Bardwan Hospital. Dr. Shukla treated me outdoor patient as an outdoor patient. He will also depose in this case. I also treated as an outdoor patient lastly till last part of 2006. I also treated as Baharampur privately by Dr. Bijoy Kumar Mondol. I cannot recollect the date when I was treated lastly by him. He will also depose in this case. Skin grafting was done by Dr. Shukla Heblem. I appeared before the medical board of Dr. Bijoy Kumar Mondol was one of the member of the medical board. I shall examine witness who has seen the accident. I cannot say who reported the accident at the police stations. It is not a next minute. I have passed Madhyamik examination. I have no such trade license of my business. I have no document to show that I had a business. I have no document to I have no document to show that I was earning 4,000 per month. I am not given the breakup of my claim. This is his evidence. Now, Akhil Kumar, page 29.
29.
Page of the that this is the evidence of PW2, Akhil Kumar Pal. That I know Jadov Kumar Das. He engaged himself in the profession of lottery ticket sale and commission agent of the stationery goods. He worked under my concern, Sarvamangala Enterprise. I used to give him a sum of 3,000 for the sale of the lottery ticket. Also issued a certificate to the extent which is a part of the affidavit and marked across. That he used to deal with the business of the commission agent of the goods. Now it is his cross as page 31. Petitioner asked me to depose in this case. I shall be able to produce document that the petitioner was working under me. I used to pay salary to him. I am a dealer of state lottery. I pay income tax and professional tax. I shall be able to show the same. I have stated correctly in my video in chief. I have heard that the petitioner was commission agent of stationery goods. There are 20 staffs working under me. It is not a fact that the certificate was issued by me. It is not a fact. This is it. So on while cross here said that I paid salary. Now completely deviated from the original claim of the petitioner. Now PW 3 Vishnu Padamondol is an employee of the Bardwan Medical College. Yes, he has produced some medical documents. Only she has produced medical documents. Traded tickets. Now is 37 on Dr. Dr. Chinmoy Day, Shom. No, Chinmoy Day. He has proposed is 37. That I am an associate professor of Burdwan Medical College and Hospital working as a faculty member. I was attached with the said hospital, and on the said date, Jadab Das was admitted in the hospital with history of road traffic accident. He was under my treatment and supervision. The other medical officers of the said hospital also attended the patient with my advice and instruction. I have already gone through the bed head ticket, which has been kept.
Also with the government records, my lords,
Yes.
that is not defect in the list.
Which has been kept as hospital original record. He said, made a ticket bear my signature and also signature of other medical officers. I observed following major injuries: fractured shaft humerus, lower 1/3, right, and fracture both fracture bone, both compound. That in my opinion, the above injuries are accidental in nature and it may cause physical deformity 80%. That a medical expert about 30 years, I am of the opinion that the patient could not lead normal life due to the above injuries. But the cross is start from 40. 39 starts, material portion start from 40. The formal patient of the bedded ticket is not written by me, but here's my signature of the written in the bedded ticket. Written in the bedded ticket that the patient suffered on fracture lower of 1/3 humerus side, of the fracture of the both forearm. Fracture injury is united within 3 to 6 months, but it may not be normal. The opinion about the percentage of the disability is not given, mentioned in the bedded ticket. I had the patient treated the patients during his from his admission in the
Prepared by Mr. Bhuvi. And Lordship is the certified copy of that is the handwriting as recorded. So after that, so I have also after the certified copy. So it will be easier to Lordship to read. So Lordship permit me, so I that for the reason I have to explain. If Mr. Bhuvi has no objection.
yes, reader. Yes. And last period say I can't say the present position of that person, of the patient. So this is the evidence part, and then the impugn judgment was passed.
Xerox also, I mean certified with what you have annexed, there is a Xerox certified copy, which you are handing over the certified.
Yes. Now this is the factual aspects and the position of the basis. So there is no confirmation whether it is a permanent or temporary. The nature of how he has assessed 80% only. Yes, sir. It may be because it may cause deformity in the hands, not amputation, nothing. And so for the 80%,
if you at least you have come to the schedule of any of the act, 80%, 80%, 70% are only case of amputations. But in the instant case, there's no amputation, admittedly. So assessment of 80% is much higher. The present position was not ascertained. What is the actual present position? Yes, I can't say about the present position. Although
Where is the disability certificate?
no, it is not
Have you any?
it should be Then I have to see the LCR. It's not my board. সেটা দেখতে হবে।
Yes.
Now, LCR is with your lordship, so yeah. Now, on the basis of I place the judgment. What the
Your entire argument was considered by the learned tribunal.
Yes.
Regarding proof of disability certificate, regarding the income, everything has been considered. Only a lump sum amount was given, 4 lakh.
Now, what is the judge has not come to a conclusion that it is a temporary or permanent. That was not confirmed. Only question of loss of earning capacity, not the disability. The earning capacity loss only comes when there is a loss of permanent disablement. The court of the Rajkumar and Ajay Kumar also indicated that for the future earning, that should be permanent in nature, and in that case, you might not work anything. But in the case of deformity, it is a case of deformity. Every person after united of the fracture, union of the fracture, even if there is a deformity, everybody can work. From my personal view, I am also my hand was broken down, and ultimately it is maybe deformity, but I am working fully. Everybody, that does not mean if it should be assessed, either it should be assessed by your lordships, even by any medical college, that whether there is a permanency, the loss of permanently or not, or 80% is a uninvasive. And even in the guideline framed by the
Both the upper limbs are in so deformity that it has been assessed 80%. How? Both are bent. This is evidence.
by hand, only
Yes,
hand.
both the hands are bent due to such accident.
Huh.
That's why the 80% disability was stated by the doctors.
But under the guideline, it is a non-structured injury. No doubt non-structured. Non-structured. It is not, in case of amputation, there is a clear. So how they have assessed? They should have followed the guideline framed by this government, central government or a state government. Under the 1995 Disablement Act, there is a guideline that was circulated. Even the guideline, look in that, there's a wrong assessment. I must say there is a wrong assessment, or whether it is a permanent or temporary. That was not.
No, learned tribunal also not come to conclusion that
No,
this is a
Not
permanent
the
or temporary,
doctor
but
said.
only perusing the infirmity in the
Yes.
hands, the learned tribunal has awarded the full life.
Whole life, but company said 80% disability.
80% disability was not considered. You read the inner page 11, inner page 8. Inner page 8 of the judgment.
Milord. Okay.
Inner page
Nine,
8.
9 page, Milord, and judgment is of the last page is 9.
Inner
Eight
page
page.
8, just last portion.
8. Yes.
Last portion.
The hospital, the middle portion,
Yes.
the doctor on this seeing the injury was opined that the said injury may cause physical deformity, may cause
Yes.
to the extent of 80%.
Yes.
And he was challenged by the OP about the said opinion, but he remained firm over the said opinion, though they admitted that the percentage of disability has not been mentioned in the bedded ticket. The handicap certificate filed by the petitioner disclosed a deformity of both upper hand with disability 80%, but I have already stated earlier that it said handicap certificate has not been proved by examining any such doctor or member of the medical board. It may be true that the said handicap certificate has not been brought into the evidence by examining the author of the same. But the same the evidence of the doctor who examined the patient during the hospitalization and gave the opinion as to the nature of the injury and the extent of disability cannot be overlooked.
Yes.
So there is no assessment
Yes.
virtually whether
No
it is
crystal
permanent.
clear, no crystal clear
no
opinion is
Considering the overall,
there.
yes,
Overall, yes,
yes,
4 lakh
is-
was given.
yes. Yes. So that's why Milord, we have prepared appeal. Now I'm strongly relying upon Milord. First of all, they have first pleaded. He has pleaded he is a businessman. He has to earn 4,000. What is the given evidence? What's proof that he has got salary of the. So when he is not clear, he misguided he is not entitled to get any benefit. He should be fair to the court. So what is pleaded that was not proved, what is proved he has not pleaded. And so far the Milord, in another case, your lordship, in case of the motor vehicle accident, so pleadings has no nothing. But I am relying on decision of the motor vehicle accident. Supreme Court said Oriental Insurance Company versus Mina Bhadial. Your lordship also or true, Mina Bhadial. So general law cannot be ignored.
Yes.
Even paragraph 10 and 11. What is much? SCT 428 SCC. ठीक है Paragraph 10 and 11, I'm reading. Before we proceed to consider the main aspect arising out of the decision of the appeal, we would like to make certain general observations. It may be that true that the Motor Vehicle Act, insofar as it relates to claim for opposition arising out of accident, is a beneficial piece of legislation. It may also be true that, subject to the rules made in the behalf, tribunal may follow a summary procedure in dealing with the claim. That does not mean the tribunal approach with the claim for compensation under the Act should ignore all basic principles of law in determining the claim of the compensation. So, general law, ordinarily the contract of insurance is a contract of indemnity. When car belongs to the owner, therefore, under the general principle, one would expect the driver of the to be included before the adjudication of the claim under RCC. That is one reason. And paragraph 11, as you also notice, that 11 provision of the Act are not intended to jettison all principle of law relating to the claim of compensation, which is still based on the tortious liability. So, my humble submission, yes.
Hon'ble is suffering with the eye problem. He assist me so I can read whatever he that I to place. I can assist to that extent. No problem.
I cover.
You just refer me the paragraph, I will read.
Yes. Now, I am also relying on the Rajkumar and Ajay Kumar case, especially paragraph 8, 9, 10, and 12 and 18. On the future, there must be some permanent disability. There must be some observation, and there will be some findings that there must be permanent disability. Otherwise, future loss cannot be granted. Now, yes, another decision where I am relying on already 2003 volume 8 Supreme Court is 740 Kashinath versus Jagannath on the point that if there is a at variance with the pleadings with the evidence, then court should not accept the same. This is a general law. What he has pleaded was mentioned in the claim petition that should be proved, and he has failed to prove that. Yeah. Yes. So for the insurance matter in 2000, volume 6 Supreme Court cases, page 622, paragraph 10. The pleadings also have a importance in this case. In this case, the insurance company pleaded in written statement that Supreme Court observed that once you have mentioned in written statement, you cannot ignore that fact. Whatever facts you have mentioned in the WS, that you cannot ignore. So in the pleadings has a role, he has to prove that.
Different stands taken by the insurer in a written statement and argument,
Yes.
which cannot be allowed.
So if I mention something in the pleading that cannot be, I cannot subsequently say that no, that is not correct. Then in that event, the Supreme Court says you have to make it correction, you make to make an amendment. Until you have made an amendment, you cannot ignore that fact also. All are based on the same principle that what is pleaded, you have to prove. What is not pleaded, then you cannot prove.
I cannot understand what is submission. If you repeat once again, second I can reply, but I'm not able to understand what is trying to say in respect of that judgment.
In respect of this judgment, he want to argue that the pleadings which the claimant has pleaded before the learned tribunal to be a businessman was not
Proof he is the
he
businessman.
no, he has not proved, but he proved that he is a salaried person. That cannot be allowed. So his argument is, in a nutshell, the claimant is not coming, was not coming before the learned tribunal in clean hands.
Clean hand has not proved, so he has no income.
So
Can make it
his income cannot be assessed like that. However, this is the argument. Yes.
And so for the unstructured, unspecified injury, our division bench has said, so there we will not entitled any gain assessment towards the future loss of income.
Future loss of income.
Future loss. একটা আছে উল্টো করতে পেরেছি যে এই জন্য আমার হাতে একটা আছে
Kotick Sek versus New India Assurance Company. So what is the principle here? In Kotick Sek, in case of non-structured injury, what is your argument?
The doctor says the evidence of disability to the extent of temporary in nature and extent of the disability 50%. Doctor has also stated it. over the future loss assessment. Well, now this is our appeal. They have not prepared any cross objection or cross appeal by the claimant. So my humble submission, the amount should be reduced on the or on the first, it should be assessed whether the disability is a permanent or not, or what is the extent of injury at all by deformation, whether there is a deformation still exists or not.
So what you want, structure formula?
No, I am saying that as there must be, if it is a future loss,
You want to entirely set aside the award or what you want?
it should be, but so the future loss, I cannot say what basis, because of the fact there's learned tribunal not given any basis for awarding the so that amount, that part would be reduced. I cannot say. I say that even there must be there's a 80% is not proved whether it is a permanent or it is a temporary, whether there is at all any existence of loss by deformity and permanent deformity. And by the now here, what is the nature of business? He is the lottery seller. So even if there is deformation in the hand, he can use the sell the lottery ticket. Even there is a deformity. So that should not be the loss on the there no award for the future income towards the future income. So
No, tribunal has not awarded anything future or anything.
this is
Nothing.
my submission. Yes,
Only awarded 4 lakh lump
4
sum.
lakhs lump sum.
So what you want? Why you prefer this appeal? For setting aside the entire award or what you want?
But I can say some pain and suffering, other things that should be, even if there is no loss of the future income in there, he should get some amount for future for loss of pain and suffering. That should have. So amount should be reduced to some
So
extent.
your claim, your appeal is the amount is exorbitant.
Exorbitant. It should be reduced. Or otherwise, if people lawsuits are there, then you have to lawsuits to defer the matter to any medical hospital of the government to assess whether there is a permanent disability or not at all. It is up to lawsuits.
No, we have to follow the principles for assessing the award on the basis of the evidences of the court. Not further evidence is required. If it is required, then I can.
That is submitting. From the evidence, there is no permanent and disability is not proved. Not the certificate was proved by the competent author of the certificate issued authority.
No, doctor appeared before the tribunal.
But he has not the.
He was extensively cross-examined by the insurance company.
And he has said, I cannot say the present position. He has said at the present position, I cannot say.
Why the insurance company not produce the claimant before any doctor?
It
Why
is,
not put
but
any
this is
cross-examination
the inquisitive
evidence?
proceedings. It is the duty of the tribunal.
No.
Even I fail.
You must have a duty being an insurance company, being a party to the proceeding.
Yes, I have.
You may have adduced any evidence, witness.
I cannot adduce evidence until the court has to prove, send it to the board. This is the duty of the court to assess, to come to findings, whether there is a disability permanent or not, whether the extent of disability. Then on the basis of that, court has to find that there is a loss of earning capacity. Ultimately, there is a loss of earning
Yes,
capacity.
court is of view that the opinion of the doctor is sufficient to
But
assess the compensation.
Rajkumar and Ajay Kumar is said that.
Functional disability
Yes.
is required to be looked into.
Otherwise, it should be by the board, and board should assess by following the principle of law laid down in the 1995 Act. That was the findings of the Ajay Kumar. That is
No,
followed.
one certificate is there which was existing.
Certificate issued by the, but that was approved by the member of the certificate issued authority.
It is not required to be proved. It is given by the government doctor.
No,
government hospital.
no. After all, what is that certificate? It is the opinion of a doctor.
It is a
It is not a
certificate
public
issued by a
document. It
board.
is not a public document. It is an opinion, like a postmortem report. It is the opinion of a doctor.
No,
Opinion
it
of
is
the
a public document, is a registered document.
No, my lord.
Registration
My,
number is
with
there.
my humble submission, certificate issued by the board is not a public document. Because it is an opinion of a doctor. It is, has to prove before the court, and on the basis of only opinion of the board, that court cannot act. Board has to come to findings on the basis of the opinion, whether there is a loss of earning capacity or not. Mere disability certificate would not come that 80% loss, that does mean the 80% loss of income.
Original document produced is the act of government officials by using the seal of the government.
No,
So what
I
is
think
the-
not, it
regarding
was
the
issued by
primary
the
evidence, it can be taken.
kind consent. Doctor's concern from Badwan Medical College was deposed. The certificate issued by the Baharampur Medical College. Not
There
that,
is no bar. There is no bar.
no, but some persons who has
Doctor appeared to prove the bedhead ticket.
waited ticket.
Yes,
He has
he
treated,
treated the doctor,
but
he treated the
but in
patient
the
at
bedded
the
ticket, there's
time of
no
accident.
mention. In the bed, he has admitted to that in prosecution, that there in the bedded ticket, there's no mention of deformity like that. No percentage of loss, it is not mentioned. It is, his assessment, it may cause 80% deformity. He has not said that it caused 80% deformity. May cause. And he also admitted, while crossed, he has said that 3 to 6 months is required for union of the fracture. But in that case, whether it is, what has happened, he can confirm that. Under such circumstances, I have leave it to your lordship.
And the patient appeared much after the 6 months before the
Yes,
government hospital of
Yes.
the Bahram,
yes.
and they were they had given the certificate with
But
registration number.
No one has come. Then I could have cross-examined him. What is the basis of the report? That is the Rajkumar Ajay said. What is the basis? I could not ask him. You have issued the what sorts of examination you have done before issuing the authority certificate.
Okay.
That is, I am leaving questions. Now,
First of all, the judgment lastly cited by Mr. Bhumi, our High Court judgment is under section 163A.
Yes.
So it is not applicable here, first of all. And lordship kindly produce the judgment in the page 3 is the specific opinion of that. Lordship also produce the judgment, page 3, our High Court 40.
Yes.
Page 3. That is the doctor stated in his evidence that disability of the victim was temporary in nature. That opinion is there. And extent to his disability 50%. Doctor also stated in evidence that victim lost his normal earning capacity. So the evidence is there. On that score, the court has come to a conclusion. Because of the case under section 163A. So this is the case under section 166. Then lordship kindly come to our case. The evidence of the doctor. The question is, it is not the duty of the tribunal or the honorable court to suo motu go through the case. As and while I invite the attention of the court, then court will look at that. But lordship, the author, who has issued the disavowal certificate, who is the member of the medical board, has come before the learned tribunal and deposed. And the insurance company shaken the doctors as per their wish.
No, the normal name of the doctor is Chinmoy
They.
Whether he was a member of a medical board.
Yes.
Chinmoy They.
They. I am associate professor of the Bardwan Medical College and Hospital and working as a faculty member of
the bedded ticket.
It's very ticket.
He proved the bedded ticket, not the disability certificate.
But lordship, he has faced the cross-examination. Now, plea which has taken by my learned friend, that plea has to be taken for the learned tribunal and to prove the question. He did not put such question, did not suggest to learned tribunal in such a way. Beyond the appeal, beyond the evidence, his sufficient absolutely beyond the evidence. This is the duty of the learned tribunal. This is the duty of the learned tribunal. So, what is the duty of the learned tribunal? What is his duty? He said the learned tribunal will suo motu will see the all.
Yes.
And that the disability certificate issued by the government hospital, that was still unchallenged. They did not take any dispute to the learned tribunal. The certificates were not issued by the, or rather the certificate not properly issued. They not a single issue they have issued faced to the learned tribunal. Now in the appeal court, they are saying who will check who will test the case. This is the case by the learned tribunal. If we place the case before the learned tribunal, in appeal court, he is trying to say the document which I have placed, this document is not like that. Document should be in nature. Document not. But why appeal court will decide that? Appeal court cannot go beyond the record. The learned tribunal consider this as a certificate. What is the plea of the plea taken by the insurance company in the appeal? Is the amount is lump sum 4,000 without coming any conclusion regarding personal loss of effect. So my humble submission, if is the amount is 4 lakhs, as whatever learned to a lump sum basis, then what is the another way? It should be go through the by multiplier proceedings.
Structure.
Formula. So Lordship, kindly decide the issue in the structure formula. And Lordship, business and Lordship, sometimes she was said, I am the businessman. Lordship, is there must be common knowledge that his Lordship is the lottery business. He purchased the lottery ticket from the borrower.
The main question in the appeal is that whether learned tribunal can assess the compensation on structure formula only or on lump sum basis.
Learned tribunal should have considered the structure formula.
No, whether it is illegal or impermissible, either under law that the learned tribunal must have assessed under the structure formula.
I cannot say that is illegal, but Lordship, every is a all of the human being. That is also a human being. These things.
No, whether it is impermissible.
Impermissible is after the multiple proceeding in the civil judgment we have placed before your Lordship. Now there is the dictum of the apex court, also as few of your Lordship. The whatever the case, injury case or death case, you should come because of so the just compensation can be ascertained.
Yes.
So inter situation can be harmonized. So one judge's think, I think it is the 4 lakhs is sufficient. Another honorable judge's think is the 5 lakhs is sufficient. So the litigant will suffer. So in the case of Pune City Supra, on that issue, only on that issue, to harmonize the entire situation. So the structure formula can be used in all cases. In case of injury, so disability will consider. In case of death, the death certificate will consider. But Lordship, now so the everybody will get the just compensation. That is the present view of the court. In earlier judgment, prior to the judgment of 2017, there is a 3 years judgment of the Supreme Court. I will show that the judgment of Lordship Sanjay Verma, the Supreme Court given a huge amount. In the judgment, Lordship, our High Court judgment, the passed by Lordship Dipankar in the case of Lordship minor, is it 12 years? The Lordship is given 11 lakhs. When because of where the Lordship, I am give respect to the all judges. Lordship, it is not that I am doing, but is the human main thing. This is the condition of the patient. This is the condition of the appellant.
That's why the constitutional bench has
That's why the
formulated
constable student and come
that there must have a structure.
harmonize the entire situation. To harmonize the entire situation. But in that case, Lordship, I as a Lordship and court officer, I can suggest to your Lordship the accident took place in the year of 2005.
Yes.
Lordship will usually consider that the 3,000 up to 10,000, but here his claim is 4,000. Lordship, it's true, I am happy for the claimant. Even then, Lordship, to rendering my service to the judiciary, is my duty to assist the court that is not proved. But I will argue is yes, it is proved. Yes, it is proved. The employer has come and say, yes, I have purchased, yes, purchased the ticket from me. I am giving salary 4,000, that I can shout on the regard. But ultimately, if I come to the judiciary logic conclusion that it is not proved, but it is all considered with 3,000 per month, then lordship will go through the structure formula. According to the future prospect is entitled to 40%. But lordship, after Unashati, Supreme Court say all the case.
Come on tomorrow on top. Please take down. The matter had it. Let the matter fix tomorrow on top. Anything.
But your lordship has got a number of matters at 2 o'clock, so perhaps we not.
No.
these matters
Today,
will not-
today these
today
matters should
nonsense.
be not taken. Today I have some. No, I have the second up for you. I have the second up for them. First up for you. Enter first up. I have called first time all matters.
Monday and Tuesday for us.
No,
আরে রিড গুলো করতে হবে
all first up.
First up.
Yes. Very good. Come on tomorrow.
I put the petition in this matter.
In this matter, I am for the responding number 4.
Yes.
That I am filing my opposition, which is already
Let
been
me-
served upon the lordship.
My lord, I am in behalf of the respondent number 1, 2, and 3, but I'm missing unconditional apologize, my lord, because our brief was lost, and after accumulated from everything, we have restored that one. And we ready the affidavit in opposition on behalf of us, but that was also lost. I am praying 1 week of time, my lord.
Right, tell your lordship, my lord, the,
2019.
only one.
Yes, my lord. At
No,
that time.
let me
that-
make my
that-
submission.
that-
Lord, this matter in 2019, direction was given to file the affidavit. College filed this affidavit. I have the main grievance against this college. University, by filing affidavit, will not develop any case. On the face of the record, I will satisfy you as to what illegal has been done. Don't require any affidavit. Kindly, without this matter, kindly see that. Because college filed this affidavit, entire submission has been stated in the affidavit. Kindly hear of this. Now, first of all, my lord, this is a promotional post.
No. Let me take it very clearly. The respondent number opposite.
4, my lord, responding number 4.
4
the
and
private
respondent
responding-
1, 2, and 3. Respondent number 1, 2,
1,
and
2, and
3. You are the for the university.
1, 2 is university and 3 is college.
3 is
College.
college. And respondent number 4 is the
the private
Private.
responding.
private.
I have filed my my lord, opposition.
So
Kept with the
you
record.
want to file affidavit opposition.
1 week of time. We already done
One
the
thing,
process.
Kindly hear me, if your lordship desire, the university, you come to file the affidavit, then lordship will give it. Yes.
No, not college.
Because I told lordship, on the face of the record, whatever the documents I managed, I will satisfy that this affidavit is not at all required. If your lordship, after hearing me, your lordship think that no affidavit is required by the affidavit, then you lordship pass it. Sir. Kindly hear
Then
me.
again delay is there.
My lord,
Let him file the affidavit first. Thereafter you start the.
It is-
Otherwise you again to
what I am
start.
submitting, my lord, the affidavit of, by the university is not at all required.
uh,
Because I have the allegation against the college.
I take these matters only on Wednesday,
I know.
second half. Okay. So next Wednesday,
next,
in the
next,
first matter,
matter,
everything-
my lord.
it will be first matter. No issue. No issue. The next day is this. Okay. So university, please take down. Please take down.
That opportunity may be given
Like,
to us, my lord, to
keep
file
it.
our reply
Keep
for
it.
another 1 week time. Because my lord, what university will say, we do not know.
No, let them file.
My lord,
Let
my
me
lord.
start the argument. Thereafter, no issue. So you are filing affidavit in opposition file on behalf of the respondent is taken on it. Stop.
Responding number 4.
Respondent number 4.
So I
Taken
filed
on record.
reply also.
The yes,
I filed reply also.
affidavit in reply on behalf of the petitioner
Private is one.
against the affidavit in opposition of the respondent number 4 is also taken on record. Stop. The respondent number 1, 2, and 3 intends to file affidavit in opposition. Learned advocate for the petitioner raised strong objection. Considering the submissions, the last opportunity is given to the respondent number 1, 2, and 3 to file the affidavit in opposition by
Monday.
by 19th Tuesday, after serving the copy of the same to upon the all the parties
An advance copy to sir.
on advance after upon serving on advance copy to other parties. Stop. Let the matter appear on 20th September as a first matter. First matter.
Read my.
Madam Secretary, appear on the petition. The matter is relating to promotion. Denial of promotion to the petitioner, though similarly situated other persons have been given promotion, and the petitioners are the employee under the Kolkata University. But the matter was heard
You
on
are,
several
you are the petitioner.
lordship. My lord, kindly see, my lord, the promotional policy first.
Now who is for the respondents?
University is
Lord,
a-
I am appearing from the University of Calcutta. I am led by Mr. Shumbu Majumdar, my lord. He is on his legs, my lord.
Very.
My lord, kindly come to annexure P2, page 35.
Page
35.
30. Yes. You are
That is the one of the promotional
petitioner is the
guideline.
Sopon Kumar Mitra.
Two petitioners are there, Sopon Kumar Mitra and Brahmananda Majhi. And my lord, in this connection, my lord, I have made an application for additional party in respect of other similarly situated person. That file is being can number 1279 of 2020.
1, 2.
79 of 2020. The applicant was my lord.
Is it appearing in the list?
Lordship. What got it?
Can number 1279 of 2020. That is
Lordship.
can 1.
Can number 1279 of 2020. Can number 1.
And number 1.
Lordship. Cause title page number 4, my lord. The applicant was Subhasis Chatterjee.
One, 1279. 2000. Yes.
And my lord, kindly see, my lord, the order dated 8th February 2023. 8th February 2023. The said application was taken up for hearing on that date, and I was directed to subcopy upon the learned advocate application for the university. Accordingly, the matter copy was served. So, I pray, my lord, before lordship, my lord, that let this application be allowed, and adding the respondent, applicant, Mr. Subhasis Chatterjee, as the petition number 3 hearing. My lord.
Can 1279 of 2020.
Lordship. That is corresponding to the can number 1 of 2020. Public service question.
Subhasis Chatterjee is the applicant.
Lordship. Similarly situated person, so I made the application. And on that very particular date, that is on 8th February, copy was served. The endorsement is here, my lord, and the copy of my application. Kindly see, my lord.
Yes, sir.
Lordship. On that very particular date, that is on 8th February. Lordship. I pray for your lordship, my lord, to make an order to that effect, my lord, and to hear the application altogether.
Yes, what is the submission?
The two additional party, my lord, they are similarly situated, my lord.
Similarly situated person. Please take down. Can 1279 of 2020.
And only one thing, my lord, since the third petitioner was not added, my lord, so far, my lord, whatever affidavits we have filed, I mean,
They are left in same.
there are two petitioners are there. This is the third one who has been added today, my lord.
regarding his factual aspect, my lord, I have to take instruction. I'm not opposing the addition, my lord. Regarding the on merits, my lord. What was the dates of his promotion? This regards to promotion. This matter.
You want the liberty to file affidavit of opposition if any.
Not required affidavit of opposition, but if any, my lord, if required,
If any.
if
And to ascertain the facts, whether it is, though it is filed in the month of February, my lord, okay, no problem there.
but he was
Every addition is
Lordship.
there, thereafter they would be liberty to
Lordship,
file on
lordship,
affidavit
absolutely.
if they require.
I have got no
if
objection
required, my lord.
if they require.
Yes.
Or by Tuesday, next Tuesday, let them take instruction and
Well,
let the
well,
matter be
well,
fixed on next Wednesday, because it's a very long
What
pending.
are the other cans?
Well, regarding other development, that is not necessary now, because during pending of this application, they were going to give promotion to other person, my lord.
Very.
So
So you are
all,
now
all those
pressing,
are not now relevant at that point
you are
of time.
now pressing can 1 of 2020 old can.
Lordship.
Okay. Can 1 of 2020 old can 1279 of 2020. This is an application for addition of parties. The applicant, namely
Subhasis Chatterjee,
Subhasis Chatterjee,
page number 4 of my application.
wanted to add as a addition of add as a party petitioner to this proceeding. Are the learned advocate, there is the petition, also are the learned advocate for the opposite party. Considering the submission of the parties, the can 1 of 2020 being old can 1279 of 2020 is considered and allowed. Stop. The Subhasis Chatterjee, the applicant, be made a party being a petitioner.
Lordship. Petition number 3.
Petitioner to this proceeding. Stop. The opposite party is at liberty to file affidavit in opposition, if any.
All right, but very next week, because my all points have been covered, my lord, there is nothing to do.
This is a regular process. If any. On or before 19th of September 2023, after serving advance copy to the petitioner,
Lordship.
let the matter appear in the same position on 20th.
Lordship.
Can 1 discussion.
Lordship. Grateful very much.
Well, lordship pleasure to keep it after, well, kindly. I was paying for 2 weeks time to file the opposition, because university, my lord, it takes time to take instruction.
Already you have filed your affidavit in opposition.
Oh, with regard to the,
Affidavit in opposition and my lord, in this
They
year,
are
my lord,
standing, they are
well, I
standing
will,
in the
same footing.
well, I will try to take only instruction. I will not file opposition, my lord. Kindly give me some more time.
For last, my lord, 4 to 5 months, my lord, they are taking time, my lord.
No, this matter
The
was,
matter could not taken up. This is
No. Matter was taken up for several times for hearing. Kindly see the order sheet, my lord. It will clear from the order sheet, my lord. They are taking for time
Only
for.
I can provide you the 27th.
Only difficulty is this, not the matter traversed through exchange of documents, not in the writ petition. We filed a comprehensive opposition to the writ petition. Thereafter, my learned friend started providing him with documents which were not on record. And these are all not relating back to 80s.
These are not part of the writ petitions.
Those are not part of the writ petition. He came up with a chart disclosing documents. We had to take instruction whether this is really correct.
That is the
Okay,
difficulty.
they are taking time. They used to take time for 1 week, 2 weeks, 3 weeks.
No, no, sir.
All were granted. I'm not
Whatever,
opposing
whatever.
that. I'm not opposing that.
You
But
have to
even
modify
after
your petitions.
and after expiry, okay, there was no objection on that.
Standing the way of a knowledge.
They were taking instruction. They are
So
paying.
when in 27th,
Lordship, then I
come that will be on 27th. Okay. So
for last 4 to 5.
advance copy within 26. Advance copy within 26. Matter will appear on 27th.
Obviously.
My lord, I am appearing for the petitioner led by Ms. Devjani Sengupta. My lord, my learned senior is on her leg praying for short Passover. She is coming.
Who is for the respondent?
No,
Very well, passed it over.
Okay.
My lord, I am applying for petitioner, my lord. I am for the respondent university led by Mr. Subroto Mukherjee. What of my lord, this is the application reply, my lord. This is the petitioner is a senior citizen, my lord. First, my lord, he is husband, my lord. What, lord, this petitioner's husband, my lord, was the was still employed, my lord. May something who retired from service on or after 1st February 2000, my lord. And it is admitted fact that said Jyotirnath Parial, the petitioner's husband, my lord, was a hostel employee of the Indian Institute of Engineering, Science and Technology, Shibpur, and he retired from service on 31st July 2001.
Yes.
After attaining age of superannuation of 60 years, which is evident from the fact that his name has been included by the main and agents of the respondent Indian Institute of Engineering, Science and Technology, Shibpur, in the list of employees who retired from service after 1st February 2000 at serial number 4. As such, the respondent authorities are bound to sanction and release the pension and family pension to the petitioners being sole legal heirs of the said deceased employee Jyotirnath Parial. But in the instant case, in spite of representation to that effect made by the petitioner, the concerned responding authority till date did not sanction and release pension and family pension to the petitioner, which is predilections of duties of bread and flowers of statutory duty and municipal natural justice. What happened in this case, my lord? I am stating the
So you are here for release of the family pension.
Yes, my lord. Family pension, my lord.
You have not received the family pension.
Yes. I am paying for family pension. What happened, my lord? First of all, my lord,
Have you filed application,
by
petitions before the authority?
Yes, yes, my lord. And this is the what happened. The kindly see page, my lord. Kindly see annexure P2. Annexure P2 of my petition, my lord.
Yes.
That is the 28th October 2014. In this case, my lord, the fourth paragraph, fourth, the hostel means employee of the government added college shall be eligible for the benefit of General Provident Fund, death or retirement gratuity and pension, including family pension and such other retirement benefit are available to the other non-teaching employee of the college with effect from 1st February 2000 as per the provisions of the West Bengal Non-Government College Employees and Day Students Homes Employees Death Cum Retirement Benefit Scheme notified by this department number such and such and the orders made thereunder. The employee who have died or retired from service on or after 1st February 2000 shall be eligible for only death or retirement gratuity. So, my lord, this petitioners, my lord, died in the year 2012, my lord, but he retired from service, my lord. That is the 2001. That is the P1. Kindly see P1, page 19.
Yes. You read the entire paragraph? You read the entire paragraph?
Page 20. Page 20.
P2.
P2, paragraph 4.
Yes, the employees who have died or retired from service on or after 1st of February 2000 shall be eligible for only
death or
retiring gratuity
as the case may be. In this case, my lord, he worked up to 2001, my lord. That is the, my lord, P1, my lord, kindly see.
No, just read out the entire paragraph.
Oh, thereafter, yes. shall be eligible for only death or retiring gratuity, as the case may be.
Yes.
And pension or family pension, as the case may be, as part the provisions of the said scheme. The benefit of general provident shall, however, not be open to those employees
Yes.
who have died or retired from service prior to the issuance of this order.
Yes.
So, my lord, this is not my case, my. So, my lord, he retired from service 2001, and now he died in the year 2012, my lord. That is my I have annexed, my lord, the death certificate. So, my lord, in this case, my lord, and that is the order, my lord. Kindly see page 22, P3, my lord. Page 22, P3.
Yes.
Our second number 2 term, he was still mess employee of the institute shall be eligible for the benefit of general provident fund, death and retirement gratuity and pension, including family pension and such as retirement benefit as are available to other non-teaching employees of the institution within from 1st February 2000. The employees who have died or retired from service on or after 1st February 2000, pension as the case may be, as per the extent rule provision scheme introduced by Government of West Bengal via the GO number such and such, the herein general provident fund, however, not be open to those employees who have died or retired from service prior to 1/2000. So this is not my case, my lord, because I retired from service 2001. That is why I have P1, my lord, I have stated. That is the.
No, you are only eligible for the death and retiring gratuity.
Yes, pension, family pension, my lord.
The family pension, you are not entitled as per the GO.
Another, my lord, kindly see. Page 4, my lord, annexure 25. Have you found, my lord?
Page 25, notes it.
Resolution. First, after careful consideration of the matter, the committee resolved the following. The list of mess employee eligible to be considered as a non-teaching employee of the institute and also eligible for all facility as per above GO such and such 2010-2015. The list of retired mess employee to be considered for pension or family pension, and the list of deceased mess employees who are in service from 1st February 2000 to 1st August 2016 is prepared and signed by Assistant Proctor and the Dean of Student Affairs was placed before the committee and the list was approved. So, my lord, this approval, my lord, kindly see, this is the signature, my lord. All this page 25, my lord, assistant registrar, professor, assistant dean, chairman, everything, my lord, that is the sign. And now, my lord, page 29, my lord, the Jyotindranath Pariyal serial number 4. Page 29. Serial number 4, Jyotindranath Pariyal, Adhar Chandra Pariyal, date of birth 31st July 1941, date of joining 1/4/1981, date of retirement 31st July 2001.
Yes.
And this is the, my lord, death certificate. This is the death certificate, page 33, P5. That he died 2012, my lord. This is my humble submission. Thereafter, my lord, application for pensioning benefit I prayed for. Thereafter, my lord, kindly see. This is the humble submission. Thereafter, my lord, the decisions I am giving, one decisions, my lord, that is in my favor. That is the, kindly see, it's a decision taken.
No, you just satisfy me. Here in page in P2, whether you are entitled to the family pension.
Yes, yes,
How?
because my lord,
P2, page 20.
P2, my lord, yes,
You are only entitled to the death and retiring benefits. No.
P2
Death or retiring gratuity.
Lordship, the answering respondent is the ME chart that is under the Union of India, Human and Resource. Because now the university is under the control of Union of India. So
Now, who are you?
take a resolution to inform the MHRP and they negate the proposal with my opposition, Lordship kindly see.
No, let her finish. Let her finish.
my lord, kindly see page 21, my lord. Page 21. I will find my lord 21, paragraph 6, my lord. And the duty hours and work pattern hour may employee shall be determined by the concerned university or the governing body of the concerned college considering their workload and other local conditions and exit. Such employee shall be bound to carry out the directions of the university or the college. So the case may be in the regard every such employee shall be liable for disciplinary proceeding and punishment thereunder.
That is separate
Also
issue.
that is the hostel mess employee, seventh number say, the hostel mess employee of the university and the college shall be considered as non-vocational, non-teaching employees of the university or the colleges and shall be entitled for such leave as may be determined by the state government from time to time, made in accordance to their work pattern and duty hours. The appointing authority shall be the leave sanctioning authority for the hostel mess employee. For state added university, the appointing authority of the hostel mess employee shall be the executive council or such other authority decided by the executive council or any other officer entrusted by the executive councils of the concerned university as it deems fit and proper. For the employees of government aided college, the appointing authority shall be the governing body. For the employees of government managing committee, administrator, and for the government general degree college, the appointing authority shall be the director of public instruction West Bengal, and for the government engineering teaching college, the director of technology education West Bengal. The existing post of hostel mess employee in all state aided university, government aided college, and government college shall be considered to be a dying cadre, and all such posts shall be treated as personal to the present incumbent. No further recruitment either contractual or permanent, including appointment or
Okay.
grounds shall be
Hard.
allowed such
I understand.
effect from the date
I understand.
to the private enterprise boards for which the state government may grant annual ad hoc grants. The details. This is my order, ma'am. Kindly see, ma'am. This is the order. Thereafter, my lord, P3. So, my lord, is eligible for family pension, my lord. And that this is the decisions of the my lord. Kindly see. This is the Justice, Honorable Justice Ashok Shutikari passed the order, my lord, on 6th September 2013, my lord. The petitioners are employed as per direction of the Director of Public Instruction, West Bengal, dated 23rd August 1988, bearing memo such and such. In the memo dated that the concerned Director of Public Instruction Director, the officer in charge, Jharkhand Raj College, to give appointment to the hostel employee as per GO such and such in the manner prescribed by the respective university or the manner deemed fit by the hostel mess committee. The direction was given to issue appointment letter without further delay. Different canteen employees who were appointed were treated as government employees, which is reflected from the staff pattern of the hostel attached to Jhargram College as well issued by the principal of the college. Although such appointment are given on the basis of the instruction of the Director of Public Instruction following the above aforementioned government order, the canteen employee were not given permanent status. The writ petition was moved with the prayer for regularization of the petitioner service on permanent basis, conferring them in the status of duty and non-teaching staff of the government college in their respective posts for the date. So, my lord, last paragraph, my lord, I am not giving the details. My last in conclusion, my lord, in my considered opinion, the petitioner entitled to get the status of permanent government employee, and they are also entitled to get the retail dues along with the pensionary benefit accordingly. The respondent are directed to treat the petitioner as a regular and permanent government employee and also release all pensionary benefit in favor of them.
Yes.
The entire expense should be completed within a period of 8 weeks from the date of communication of this order, my lord.
Yes.
So this is the order, my lord. So, my lord, my humble submission is, my lord, this petitioner is, my lord, is the senior citizen, my lord. So, my lord, he got the family pension, my lord.
Very good. Yes.
2014 Lordship, Bengal Engineering and Science College has been transformed to IISc, and now it is controlled by the Union of India and the Ministry of Human Resource and Development. They will take decision about the family pension of the petitioner, and we made a request to them, but that was turned down by the HRD. And again, we decided that we will again request the HRD to give the family pension of the petitioner. Take some time. For the main answering respondent is the HRD. There was a direction for filing opposition by the Union of
Was there any direction to the debate?
Well, whether that was a part of the inspecting of the department. The last commission was
No, it is not the prudent way. The way, who is the authority in the central government to decide the matter? Let's decide the matter. The person cannot proceed to there. Then
I will not file my deputy as we hear another discussion. So the other matter was I have filed deputy. Single matter.
Let it be, my lord, Harding Park, my lord. Harding Park.
so I am providing you the opportunity to take the instruction only, not the affidavit in opposition.
I cannot file deputy. That is it. There.
Okay, please take down. The matter heard in part. Learned advocate appearing on behalf of the Union of India seeks some accommodation for taking instruction. As the matter is heard in part, so the learned counsel appearing on behalf of the Union India is requested to enlighten this court regarding the queries made herein by 20th, next week, by 20th. Place the matter on 20th for further hearing in the same position. 20th. 20th, what? At 2 p.m. All at 2 p.m.
Well, in item 52, a short passover was taken
Yes,
So would it be my lord's pleasure to take it now? My lord, in fact, the other side is not here. Would it be my lord's pleasure to pass an order directing us to serve a notice on next Wednesday
you are appearing on.
for the petitioner, my lord?
I am here for the OP, opposite party, respond. Where is the response?
If my respondent advocate is Mrs. Tapati Samanto, she is not here. So what I'm submitting before my lord, that
Let me call out the list, thereafter I will pass out.
total list.
Yes, if it is not available today, I will fix the matter next week. Okay,
Shall we wait or Passover matter, will it be called or shall we go?
that I cannot say. Very well, next matter.
Affidavits have been filed. But I'll just make a gist of the matter. The issues are very small. The pleadings may be voluminous, but the two main issues. But one is the maintainability of the writ petition. But two coordinate benches, my lord, have held that the writ petition is maintainable. But I have those judgments, my lord, that the learned advocates have appeared in some of those matters, my lord, and the Honorable Division Bench in an appeal taken out from one of those orders have held that prima facie writ appears to be maintainable. That appeal is pending. But there are two judgments of coordinate benches, concurring judgments, holding that writ lies against the respondent college. Now, the second is the merits. But this is a principal of a college, of the respondent college. He was on probation. On an earlier round, Malad, there was a termination order against him, which was eventually set aside by the Honorable Division Bench. The Honorable Division Bench directed his reinstatement and provided certain riders as to what the college ought to do and ought not to do in the event they choose to terminate him again within the period of probation. My humble submission is that, Malad, those directions were flouted. In the affidavit in opposition, they admit that those directions were not complied with. They say, Malad, on the other hand, that those directions, Malad, very intimidating. But those directions
compliment.
No, you please sit down.
Are contrary to law, and those cannot be binding on the college. That is the stand that they have taken. This is the first point, that the writ petitioner was not put on notice about his alleged deficiencies before his second termination, although this was required of the college. That's a clear, Malad, violation of the order of court, and the consequence has to follow. And the second and a more subtle point is that the order of termination, Malad, was passed by an authority which was lower than his appointing authority. This is a borrowed principle from Article 311, but the Supreme Court has held that this applies is a general principle of law, irrespective of Article 311, which is applicable to government servants. These are the two main points on merit. The issue of maintainability has been answered in one of the writ petitions in which my learned senior friend has appeared. As on date, my lord, I don't think an appeal has been taken out from that. But I'll now come to the pages. My lord, I won't be long. I'll come to, my lord, the relevant page of the Honorable Division Bench's order, which required that the appellant should be intimated of his deficiencies. But because the writ petition was filed during, my lord, when the COVID pandemic was at its peak,
Yes.
the entire judgment was not annexed, but that is there in the affidavit in reply.
I was not of the state. It is not maintenance. It's a private college. There is no control. Article 12 is not. That is the judgment of the apex court. In my favor.
No, he is arguing that matter was decided by the division bench.
That is kept open.
That concurring judgment.
Now the Supreme Court has said otherwise. Supreme Court says there is no control. Yes, he is discharging, the college is discharging public duty. But the employees are not governed under the article.
The in the recent matter, my lord, which was decided as late as on 16th August 2023, my learned senior friend had appeared for the college. Here also, my lord, the learned single judge concurring with the earlier judgment has held that the actions are amenable to judicial review, paragraph 24.
That on matter is pending, that's what kept open, not decided. I have the apex court judgment.
Apex court, this college, these matters have not traveled to the apex court.
No, the ingredients of an authority which can be governed under Article 2.
This judgment is in respect of a minority college, St. Mary's.
It doesn't matter.
Yes.
No, let me hear about the maintainability.
Yes, yes.
That will be better.
The
Let-
ingredients mentioned therein is fitted with the maintainability point we are taking in this college. There is no control.
My lord, kindly
Neither Palazzo-
permits me to place the judgments of the coordinate benches in respect of this college, which still hold the field. They have not been stayed, they have not been reversed. The second of those judgments is, my lord, as fresh as a month ago, 16th August, Justice Hiranmay Bhattacharya. My lord, first, the judgment of the first judgment, Honorable Justice Shampa Sarkar. I have the paragraphs of that judgment which are in my favor. And then because the college is a minority college, there, the one judgment. No, this is a coordinate bench. That is good. I'm listening after that. But one thing is there, if the point of demur is to be argued seriously, they have to argue first.
Point of maintainability.
Yes.
Yes.
I start with the judgment cited by people.
Yes.
So the recent judgment. Kindly come to paragraph 23. Why the honorable single judge concurred with the another honorable single judge? That has been paragraph 23. May I read? The institute is imparting technical and higher education to the public in general. Imparting education is undoubtedly public duty, I admit. It is well settled that the action of the body.
No, what judgment you are reading?
So Justice Hiranmay Bhattacharya handed over to my lord.
No.
This Shampa Sarkar.
That has been appealed against. Appeal court kept that point open.
Has held that the prima facie.
Okay, let me see.
This has not been appealed against. The second, 16th August 2023.
Not necessary. One appeal is sufficient because of the reason. This is Justice Hiranmay Bhattacharya judgment.
Yes.
Kindly come to page 23.
WPA 507 2020.
Kindly come to straight away paragraph 23.
Refer me the page, it would be better.
Page 12. This paragraph.
Paragraph 12.
Paragraph 12.
Page 12.
Paragraph 23.
Yes.
The institute is imparting technical and higher education to the public in general. Imparting education is undoubtedly a public duty. It is well settled that the action of the body discharging a public function or performing a public duty is amenable to judicial review by constitutional courts. The coordinate bench, the coordinate bench, after taking into consideration the various documents, including the memorandum of association, the articles of association, as well as the fact that the members of the society were nominated by the government of West Bengal, arrived at a finding that the pervasive control of the Department of Higher Education, Government of West Bengal, with regard to formation of society and its administration is obvious. Then, this court is not inclined to take a different view, merely because of the fact that the maintainability issue has been left open in an appeal arising out of the said decision. Sentence of the appeal cannot in any way even destroy the binding effect of the said decision.
Yes.
So, in fact and in effect, one appeal is pending regarding the maintainability issue. On that ground,
Lordship was of the view that I am not taking any part. But
Matter is pending for
this is pending for decision before the appellate court. Now, in the meantime, a Supreme Court judgment delivered by the appellate court. That I want to rely before my lord. Copy de? Copy nahi?
Not in the meantime. This is a judgment, I think, of 2022.
22.
It ought to have been placed before.
It is here.
It was
But in appeal court, it is not.
in
So
place.
someone has to decide that one. তো দেনা
আমার নেই, আমার মোবাইলে আছে। আমি প্যারাগ্রাফটা বলে
just a minute, my lord, sorry.
You please read out.
My lord, it's a big judgment. Reading out do it not do. My lord, I can read out the concluding portion.
Yes.
Probably that will help my lord to. After considering all aspects, factually he is correct. It's a minority institution, but it is nothing turns on it.
Article 30.
Even if it is a minority institution or non-minority institutions, the principle declared, the ratio decided by the judgment has to be applied. What is the ratio? According to my humble reading of the judgment is, we may sum up for our final consideration as under. An application under Article 226 of the Constitution is maintainable against a person or a body discharging public duty or public function. Public duty cast may be either statutory or otherwise, and where it is otherwise, the body or the person must be sworn to owe that duty or obligation to the public involving the public law. Similarly, for ascertaining the discharging of public duty, public function, it must be established that the body or the person was seeking to achieve the same for the collective benefit of the public or a section of it, and the authority to do so must be accepted by the public. Even if it is assumed that an educational institution is imparting public duty, that the act complained of must have a direct nexus with the discharge of public duty. It is indisputably a public law action which confers a right upon the aggrieved to invoke the exclusionary jurisdiction of Article 226 for a prerogative writ, individual wrongs or breach of mutual contacts. It is a contract service without having any public element, is as its integral parts cannot be rectified through a writ petition under Article 226. Where courts have intervened in their exercise of the judicial discretion under 226, either the service conditions were regulated by the statutory provisions, or the employer had the status of a state within the expansive definition of Article 12. It was found that the action complained of has public law element. So those are the two components: the statutory violation of the rules, or it is direct nexus with the object to be achieved by the public. These are the two eventualities where it is maintained.
It must be a statutory authority.
And the violation is statutory violation. Both component has to be there, not all. It must be consequently held that while a body may be discharging a public function like this, or performing public duty, and thus its actions becoming amenable to judicial review by a constitutional court, its employees would not have the right to invoke the power of the High Court conferred by Article 226 in respect of matter relating to service, where they are not governed or controlled by the statutory provision. My lord has a regular example is CSC also. You can file a writ if there is any shortfall in the discharge of the duty of giving electricity, not giving electricity. But their employees cannot come to court that their authority, their employee is discharging public duty, so they are amenable to this. This is the minor distinction made. An educational institution may perform minor functions; those functions have to fall within the domain of a public function or public duty, be undisputedly open to challenge and scrutiny under Article 226 of the Constitution. The actions of decision taken solely with the confines of an ordinary contract of service, having no statutory force or backing, cannot be recognized as being amenable to challenge under Article 226 of the Constitution. In the absence of the service condition being controlled or governed by the statutory provision,
I emphasize. In the absence of service condition being controlled or governed by the statutory provision, the matter would remain in the realm of an ordinary contract of service. Even if it be perceived that imparting education by private unaided school is a public duty, within expanded prescription of terms, an employee of a non-teaching staff engaged by the school for the purpose of its administration or internal management is only an agency created by it. It is immaterial whether A or B is employed by school to discharge a duty. In any case, the terms of employment of contract between the school and non-teaching staff cannot and should not be construed to be an inseparable part of the obligation to impart education. This is particularly in respect of the disciplinary proceedings that may be initiated against a particular employee. It is only where the removal of an employee of non-teaching staff is regulated by some statutory provisions. Its violation of the employer in contravention of law may be interfered by the court, but such interference will be on the ground of breach of law and not on the basis of interference in discharge of public duty. But here the Supreme Court has made it abundantly clear. If there is disciplinary proceeding, if it is statutory violation, yes, you cannot say that my employer is discharging public duty, so I am amenable to jurisdiction when my employment is a private contract. From the pleadings of the original writ petition, it is apparent that no element of any public law is agitated or otherwise made out. In other words, the action challenge has no public element, and writ of mandamus cannot be issued as the action was essentially private character. In view of the aforesaid discussion, we hold that the Single Judge of the High Court was justified in taking a view that the original writ application 5/1 herein under 226 is not maintainable. Here, my lord, it is a private college.
Yes.
Initially, I must be candid with my lord, land was given by the state government. State government has a management by virtue of a post, somebody is the managing committee member. But so far as the employment is concerned, this is governed under the rules of this institution. There no control is there. And this is a case of professional. But initially, there was a mistake on the part of our college that with some observation, his profession was not extended. That is stigmatic. The order after ordering wait, that no, you cannot do that. Thereafter, they give him a chance to complete his professional period. And yes, with a direction to inform. But this direction is not find place in any of the authorities of India that a professional has to give in a notice. You have said that you are not necessary for a while. So there is no stigma. The professional can challenge it if the reason is maintainable on that ground. First of all, let my judgment satisfy your lordship that it is maintained. In view of the judgment of the election. But I will not hand over this. It is fully marked. Fully marked. My lord is accustomed with this.
Give me the paper.
Paper is my lord marked.
Not on maybe, give me the paper. It may be the mark. It is helpful.
I'm sorry, my lord.
Very well. It is helpful. No issue.
দেখো সব দেখো
Yes.
Another two things I want to show to you, lordship. But your lordship, the opposition is my lord. Opposition দেওয়া আছে? The opposition on behalf of
The respondent number 5 and 6.
respondent number 7 and 8. Backseat of Mr. Biplab Ranjan Bose.
affidavit declare five and six. Affidavit declare five and six.
করেছিস তো বুঝতে পারছেন না এই দেখুন তো বিপ্লব দাসের ভ্যাকসিন First of all, main contents are I will reply on another.
কেন তো ভাগ করে করে
আমি আর তুই চালাবি আমি রেডি না হতে
আমি একটাই জানি বাকি আমরা তো ওই লোকটা একেবারে থার্ড ক্লাস ছিল কি হয়ে গেছে বিপ্লব ঘোষ বিপ্লব দাস আপনি বলুন একটা ডুপ্লিকেট কপি আপনি
কি হচ্ছে ভাইরাকে আটকে রেখেছি আমরা
ডুপ্লিকেট কপি আপনি
আরে দেবো তো কপি আছে
তো আস্ট্রাইল অ্যাডভোকেট
আরে যাই হোক
Nine.
for this day I'll tell you take this I will replace it by an affidavit reaffirm. Now kindly come to page 57. This college 57 58 this college is an AICT affiliated college the technical education.
Yes.
So it is required an affiliation from the All India Technical Education. Kindly come to page 58. This is a notification of All India Council for Technical Education. 58. Well, got it at the top. Kindly turn over. Is a definition section is here. And kindly to come to 2.16 next page.
2.16.
Government aided institution. Why I am saying this? If it is government aided institution, my submission will go through guidance.
Yes.
Now, what is government aided institution? Means technical institution that meets 50% or more of its recurring expenditure out of the grant received from the government or government organization. Here, my lord, not a single paisa is being given by the government or recurring. I request your lordship to mark this because this will be my submission. Apart from the judgment of the apex court, there is no financial control. At least I can show to lordship from this. Then kindly come to use. What? Now, my lord, I will request you also to page 98. This is UGC because we are governed under both technical education and UGC. Page 98. This is the letter from the University Grants Commission to the registered West Bengal University of Technology.
Yes.
And now, my lord, kindly allow me to read with my lord. I am directed to refer to the letter number such and such received from the principal RCC Institution of Technology. This is this college. Such and such on the above subject, and to say that it is noted that the following college is unaided. I want to got it.
Yes.
Unaided stroke self-finance and temporarily affiliated to West Bengal University of Technology. Now another. Kindly come to page 70. This is the annual report issued by the Higher Education Department, Government of West Bengal.
Page 70.
72.
72.
Thereafter I will see. This is the report. Kindly come to page 75. C.
Yes.
C. The list of self-financing engineering and technology college. I have got that C.
Yes.
Kindly mark as C is a list. Bottom is the list. Below is the list. Kindly turn over the page. You will find the name of 77. You will find our name. 10.
RCC instrument.
So even the government is saying that this is not a grant getting college, it is self-financing.
Yes.
So these are the three documents I have shown to your lordship, and the judgment of the apex court, which says that there is no control, and the Justice General Bhattacharya has not entered into the arena of this dispute, which I invite your lordship to enter, because of the corporate bench passed an order against me, and the appeal court kept it open. So someone has to decide. Now this is my lord. My lord is to decide. So now, this slate is clean. So it is your lordship's decision whether this, on the basis of the judgment of the apex court and these documents, whether it is maintainable trust.
Yes.
Here I have my father.
Yes.
Eight page.
Yes.
And to sort of mitigate the impact of the Supreme Court judgment, I place before my lord the effect of judgment of a coordinate bench. What options are there before my lord? This is a bunch of judgments, my lord. The others pertain to merits, but the last judgment in this bunch, list of these 2014-13 SCC 759. This is, my lord, the duty of a honorable single judge when confronted with, my lord, judgments of a coordinate bench, my lord, which as on date hold the field. This starts at page 51 of the bunch. My lord will kindly turn to paragraph 15 of that judgment. Running page 57. Running page 57. 765 of the report.
Yes.
Kindly sees paragraph 15.2. An earlier decision may seem to be incorrect to a bench of a coordinate jurisdiction, considering the question later, on the ground that a possible aspect of the matter was not considered or not raised before the court, or more aspects should have been gone into by the court deciding the matter earlier, but it would not be a reason to say that the decision was rendered per incuriam and liable to be ignored. The earlier judgment may seem to be not correct, yet it will have the binding effect on the later bench of coordinate jurisdiction. Then, my lord, the quote from that earlier report, my lord, State of Bihar, easy course of saying that the earlier decision was rendered per incuriam is not permissible, and the matter will have to be resolved only in two ways, either to follow the earlier decision or refer the matter to a larger bench to examine the issue, in case it is felt that earlier decision is not correct on merits. So, my lord, two coordinate benches, my lord, one as recent as a month ago, have held that the college is amenable to judicial review. Both were service matters. The first one, my lord, which Justice Sharkar decided, was a case of.
Whether it was decided?
Yes, I'll
Not
place the
decided.
judgment in extensio, especially the first one, Justice
As
Sharkar.
argued that that was not decided actually.
In the first one was decided. That is a coordinate bench. I'll place that judgment, but Manad, at least 10 pages were Manad spent by the Honorable Judge Manad in deciding the issue. Kindly seize the certified copy, Manad. I have handed that over. Not a server copy, the certified copy, stitched probably. Yes.
Justice Sampasaka.
Yes. My lord will kindly come to the narration of facts from page 4. My lord, facts relevant to decide the issue of maintainability. Page 4.
Yes.
It really recites the history of the founding of the college. When Mr. Joydeep Kaur had appeared for the college, his submissions are recorded. Then Mr. Bikash Bhattacharya was leading me. At page 10, we'll find the submissions made on behalf of the writ petitioner there. At page 10. Kindly comes to page 10. Mr. Bikash Ranjan Bhattacharya, learned senior advocate, assisted by me, appearing on behalf of the petitioner, rebutted the objection with regard to maintainability of the writ petition and stated that the college was an agency and or instrumentality of the state and therefore an authority within the meaning of Article 12 of the Constitution of India. He submitted that the state college was a unit of a registered society under the Department of Higher Education, Government of West Bengal, and was functioning with active collaboration of the Department of Higher Education, Government of West Bengal. Since inception, the said college was a center under RCC Center, which merged with, this is Department of Electronics, DOSEACC, a society run by the Government of India, Ministry of Communication and Information Technology. In this period, 2003 to 2005, the said RCC IIT was under an ad hoc committee headed by the Joint Director, Directorate of Technical Education, Government of West Bengal. On and from April 21st, 2005, the college came under RCC IIT Society, an autonomous society whose board of management was headed by the Department of Higher Education, Government of West Bengal, and the other members of the board were also nominated by the Department of Higher Education, Government of West Bengal. The society was formed by a notification issued by the, I'm coming to page 11 now, Higher Education, Government of West Bengal under the order of the governor. That this indicates pervasive control. In an advertisement issued by the government and also in the annual report of the said college for the year 2008-9, the said college has been described as a government-aided college. The duty exercised by the society was essentially a public duty. Only the salary of the staff were fully paid by the said college from its own funds, but the central government and later the state government had made investments in the said college and provided financial aid. RCC IIT was a state government-sponsored autonomous society substantially financed by the Government of West Bengal. Both AICTE and Government of West Bengal recognized the said college as a government-aided college. Under the provisions of the Memorandum of Society, this I'll place, my lord. All members of the Board of Management, including the chairman, were to be nominated by the Department of Higher Education, Government of West Bengal, and no member could be expelled or suspended without the consent of the Department of Higher Education, Government of West Bengal. Any variation in the constitution or rules of the society required prior approval of the state government. Therefore, the government had a deep and pervasive control over the entire affairs of the society which ran the said college. Clause 3, bracket 14 of the Memorandum of Association of the Society stipulated that prior approval of the state government was needed for any variation in the rules and regulations of the college. Mr. Bhattacharya, my lord, relied on those decisions, my lord. Now, my lord, the issue is decided in regard to at page 12. The discussion starts there. My lord, the pervasive control, the Honorable Judge, my lord, holds at page 15. The paragraph at the middle of the page. In the regulations of the society, the Board of Management has been defined as the governing body responsible for the management and affairs of the society. All the members of the society are nominated by Department of Higher Education, Government of West Bengal, middle of page 15.
Yes, I got.
For any expulsion or termination of any member from the Board of Management, the consent of Department of Higher Education, Government of West Bengal was required. It is page 15, para number 9. Page 15. In the event of any vacancy accruing in the board due to resignation or death or otherwise, it was to be filled up by nomination by the Department of Higher Education, Government of West Bengal. The chairman of the board and members were nominated by the Department of Higher Education. The Board of Management had the power to frame rules and regulations for the management and administration of the institution set up by the society and alter or vary the same from time to time and make new regulations. The Board of Management, comprising of all nominated members of the Government of West Bengal, was in overall charge of the society and its assets, etc. Any organization operating under the said society, like the said college, would be governed according to the service rules, administrative rules, academic rules, and financial rules of the society. A governing body constituted as per regulations framed by the Board of Management looked after management of the said college. In case of vacancy accruing in the governing body of the college owing to resignation or death or otherwise, the vacancy was to be filled up by nomination of the Board of Management of the society in consultation with the state government. Thus, it appears from the Memorandum of Association that the Board of Management was in charge of the overall management and control of the society. The board comprised of members, all of whom were nominated by the Department of Higher Education, Government of West Bengal. The Director of Technical Education, Government of West Bengal, was the chairman of the board. But more than, my lord, the contribution of funds, my lord, recent judgments of the Supreme Court have held, my lord, the twofold, my lord, nature of duties, A, and B, my lord, the impact and control of the government in the institution concerned. These are the deciding factors rather than, my lord, the percentage of funds, my lord, the college gets from state aid.
Yes.
Here, my lord, admittedly, my lord, even IITs do not get salaries, pay their teachers out of their state aid. It's their own funds. But this judgment goes on to hold, my lord, after, my lord, relying upon a number of decisions, that because of the pervasive control of the state government, my lord, this has to be, my lord, an authority and agency of the state and amenable to writ jurisdiction. This was a case of, my lord, dismissal of an employee. The learned judge held that there was bias in the inquiry proceedings, and the Honorable Judge set aside the proceedings. After holding, the writ petition was maintainable, even in respect of a service matter concerning the college. And Honorable Justice Hiranmaya Bhattacharya has, my lord, concurred with it. Not that he had very much options.
No, what is the finding? What is the finding?
Of Justice Bhattacharya.
No, in this specific finding regarding maintainability.
But she, my lord, goes on to the decision cited by the parties, and
Has been preferred from this order.
yes, if my learned friend has a copy of the appellate court's order, but the Honorable Appeal Court has said prima facie the writ appears to be maintainable. I have a copy of the order. There was no stay. State of West Bengal. I'll certainly come up with that order on the next week. এটার মধ্যে দেখো তো reply এর মধ্যে page 17 the Honorable Judge continues to
Enter into the merits.
Yeah, no, she hasn't as yet. But further grounds in support of maintainability. Page 17.
Yes.
The government of West Bengal has also taken a lead role in the management of RCCIIT prior to registration of the society. Initially, it was the central government, then it was the state government which held sway over the affairs of the society. Lastly, the central government permitted the state government to interfere into the affairs, and that is why the Board of Management had 90% of the, I'll place those orders nominated by the state government. That itself shows. But even a writ petition or an RTI application was referred to the state government for its opinion. I have those papers annexed also. In fact, very curiously, unknowingly, the affidavit in opposition has those papers. Page 24 kindly comes to it. Perhaps this is the conclusion. And kindly comes to page 24. The ultimate conclusion was that if in the cumulative assessment of the facts, it was found that the state played a dominant role functionally and administratively over a body, and then the said body would be amenable to writ jurisdiction under Article 226 of the Constitution of India. In the instant case, a dominant role had been played initially by the central government and later on by the state government, as evident from records. The law was further developed by the Honorable Apex Court, and the test was no longer restricted to the role played by the government. Another test propounded by judicial decisions as to whether an authority was amenable to writ jurisdiction was to examine, in the first instance, the object and purpose for which the such body or authority was formed. Clearly, the said college performed a public duty, public function in imparting technical and higher education to the public. The management of the college was under direct supervision and control of the Board of Management of an Autonomous Society under the Government of West Bengal, comprising of all the members nominated by the state government. Even if salary of the petitioner was paid from college funds, considerable amount of public money was spent as aid to the college. The college discharged public function by imparting education to students. The college was bound by the rules of the affiliating university. Thus, employment in such an institution, therefore, is not devoid of public character. The service conditions of the petitioner in the college was not merely private in nature. Then again, the Anadi Mukti Sadguru 2009 decision, which really holds the field till today. And this will come to Janet Jayapal. This is where it was said that educational institutions, I have a list of 3 decisions. I was not expecting this really. After 2 successive coordinated benches holding in my favor, I'll place those. Kindly turns to page 29 now. Yes. In the instant case, pervasive control of the Department of Higher Education Government of West Bengal with regard to formation of the society and its administration is obvious. The said college is run by the said society, and the college has been described as a unit of the society. which was an autonomous body of the Department of Higher Education, Government of West Bengal. In all official documents, the college has been described as a government-aided college. Thus, the decisions relied upon by Mr. Kaur appearing for the college is not applicable. Then, Malad, the decisions are discussed, and eventually, Malad, the Honorable Judge at page 31 enters into the merits of the matter. There's 18 number page. Kindly, Malad, I have been instructed to submit, Malad, and to draw your Lord's attention to page 18. There's a finding of the Honorable Judge.
Page 18.
18. First line. All these documents referred to herein above clearly indicate that RCC IIT Society was a public authority and an agency or instrumentality of the state. It's a good thing, Malad, when clients are professors, they know what to show to the Honorable Judge. And in view of this, I'll place just one or two further documents, Malad, which will stare at one's face really. And the Malad word of caution from the Honorable Supreme Court regarding Malad judgments of coordinate benches and when to hold them as per inquiry and when not to. That is there. My Lord will now kindly turn to the writ petition where the memorandum of association is there, which was, my Lord, extensively dealt with by Justice Sharkar. I'll just draw my Lord's attention to one or two clauses to show the, my Lord, effect and control of the government in the affairs of the parent body. This society is the parent body. The college is under it. So the society has a board of management heading the college, supervising the affairs of the college, and below it, the board of governors of the college. The hierarchy is board of management of the society, below it, board of governors. The first point I took was, although the appointing authority was the board of management, I was terminated by the board of governors, which could not have been done. Jurisdiction, will come in its way, because the appointing authority or higher authority can only dismiss or terminate. The first decision in the bunch is on that, irrespective of Article 311. I'll come to the judgment later, Malad. Kindly comes to the memorandum of association, Malad. Page 51 is where it starts. I'll just draw my Lord's attention quickly to some salient features. Page 58. But this memorandum of association is what binds the college and what binds the authority of the college. Starts at page 51. I'm placing certain clauses from page 58.
Memorandum of association.
Yes. Clause 4A.
Yes.
Members of the Board of Management will be nominated to the society by the Department of Higher Education, Government of West Bengal. My Lord will kindly mark that. The next page, my Lord. Expulsion of members, page 59 at the top of the page. If any action of a member is found by the Board of Management to be detrimental to the interest of the society and one in violation of the regulations of the society, he may, after due inquiry, be suspended or expelled from the membership of the Board of Management with the consent of Department of Higher Education, Government of West Bengal. The said decision will be taken by the EOGM or AGM of the Board of Management, and by adopting a resolution to that effect by at least 2/3 members of the Board of Management present at that meeting. So, my lord, the consent of the Department of Higher Education, Government of West Bengal, was a prerequisite for expelling or, my lord, suspending a member. My lord, the next clause, filling up of vacancies in the board. In the event of any vacancy occurring in the board due to resignation, death, or otherwise, it shall be filled up by nomination by the Department of Higher Education, Government of West Bengal. My lord, 11, which gives the constitution of the board, and then, my lord, the paragraph, not the last paragraph in that page, but paragraph above that. The chairman will be nominated. This is, my lord, under Board of Management, the constitution of the Board of Management.
You are reading West Bengal Society Registration Act.
I'm reading the Board of regulations of the Board of Management of the college, which is a registered society under Societies Registration Act. To persuade my lord to hold, as the other honorable judges have held, that the control of the state government in the affairs of the board is all pervasive. Kindly comes back to page 59.
Yes.
The second last para at of the page. The chairman will be nominated by the Department of Higher Education, Government of West Bengal.
Yes.
So the appointment, the expulsion, the membership, everything, the Government of West Bengal's Higher Education Department has its way. Kindly comes to page 60 now. Again, the second last paragraph. And the third class, Roman 4 and Roman 5. Roman 4, to frame the constitution and regulate the procedure of such committee, body, and to delegate to them such powers which are in conformity with the regulating authorities like the state government, AICTE. So the regulations have to be at par with the regulations of the state government and All India Council for Technical Education. The college is not left on its own to frame any regulations it chooses. And the next clause, my lord, to frame such rules and regulations for the management and administration of the institution set up by the society and alter or vary them from time to time and make new rules and regulations, provided that such rules and regulations shall in no case be inconsistent with the rules and regulations of the state government and other regulatory authorities. But the learned judges who heard college matters before my lord have held is enough to show that the control of the state government in the affairs of the college.
Yes.
Now, my lord, I wish to affidavit in opposition, my lord. Resolution of my lord of the meeting of the Board of Management, which is at page 103. Oh, this possibly is not with my lord. Oh, my lord has got a copy, my lord, handed over.
Yes.
Page 103, kindly see. This is minutes of the meeting of the Board of Management.
Minutes of meeting.
Yes, I am placing reliance on pages 115 and 16. What the college Board of Management did. Page 115 and 16. In fact, the last two pages.
Yes.
My lord, at the bottom of the page, M12.1 and M12.2. Regarding the court cases, the board directed that as the issues are sub judice and as the state government has taken the responsibility there, therefore no discussion could be held in this meeting. So the state government takes up the responsibility of looking into the court cases filed by and against the college. And the next, M12.2. In connection with the ongoing inquiry against Shukla Banerjee, assistant professor, the board directed that all inquiry details shall be submitted by the institute to the legal cell, Higher Education Department, Government of West Bengal. If the college was any other private self-financed college with no nexus with the government at all, why such activities? Next page, Malad. A resolution is passed. Resolved that all details of inquiry against Mrs. Banerjee, assistant professor, shall be submitted by the institute to the legal cell. Then the next matter. Apropos the matter of RTI Act and appointment of public information officer, the board decided the matter shall be referred to the legal cell, Higher Education Department. And a resolution to such effect is taken. So even the public information officer under the RTI Act, who he or she will be, is decided by the legal cell, Higher Education Department. Malad, in paragraph 8 of my reply, at page 17, replies that voluminous thing, Malad.
Yes. Page
8, para 8.
Para 8. Yes.
But these contain the relevant pleadings, my lord. I will not travel, my lord, in its entirety. If necessary, I'll file a written note, my lord. And the documents are all there concerning why, my lord, this college has been held to be an agency and instrumentality of the state, and therefore amenable to writ jurisdiction. Because, my lord, most of the facts are recited already in the judgments of the two honorable judges, my lord. I will not repeat those here, my lord. It's not necessary. Just one or two, my lord, papers which are subsequent, which were not there in the pleadings. Like that. Yep. List of dates.
And then hand over fresh copy.
This in the reply, my lord, I'm not able to find it actually. My lord will find once I am able to find it. But that, my lord, even the files, my lord, these are I found it, my lord. Kindly turns to page 302. This is an RTI disclosure. Annexure R24.
R25.
Yes, R25 is the file movement tracking.
Yes.
And my lord will find that writ petition, which was actually decided by Justice Sarkar, but the file went up to the special secretary, the principal secretary, to the honorable minister in charge of the honorable higher education department. My lord, it is an unusual interest to take in a college matter, my lord, in respect of a college teacher, unless the state government holds sway over the affairs of the college. Even the appointment of the acting principal of the college, that file, my lord, note sheet and all, those also went, my lord, to page 307, 308 to the directorate of and secretary level, higher education department. 307 and 308. Siddhartha Bhattacharya, my lord will find the name at page 308, is the person who was acting as, my lord, principal temporarily in place of the writ petitioner when the honorable division bench, my lord, held the termination to be bad. Education department. The note sheet has his name. The letter trail goes back to him.
Yes.
But these are, my lord, really efforts to persuade my lord to believe that the college is not run-of-the-mill, my lord, private college. The government holds sway over the affairs of the college. Maybe not funding the salary of the teachers, but otherwise having deep, pervasive control over the affairs of the college. Even as petty things, my lord, as who will be the RTI, SPIO, Special Public Information Office. Those things are also decided at the departmental level and not left to the discretion of the college. The judgment of Honorable Justice Bhattacharya, my lord, he also, my lord, dealt with these facts here. This is a recent judgment, so facts subsequent to, my lord, those that were there before Justice Sarkar were there. Kindly comes to, my lord, page 7. Same arguments as here were advanced there by Mr. Basu. Page 7, paragraphs 15 and 16. Is where, my lord, the submissions of Mr. Basu are recorded. Then paragraph 17. Since the maintainability of this writ petition is under challenge, this court has to first decide whether a writ petition against the institute is maintainable. Then again, the decisions are cited, and at page 24, my lord, this court holds that the actions of the institute are amenable to judicial review. But there are 3 judgments of the Supreme Court which have been dealt with by Justice Sarkar, really. But since there's such stiff resistance from the other side, I'll come back with those 3 judgments, in my bunch, include them in my bunch. 2020, volume 14, 2012, volume 12, and 2015, volume 16. 2020, volume 14, SCC 449. 2012, volume 12, SCC 331, and 2015, volume 16. It's Janet Jaipal. It's page 520. I'll come back with Xerox copies. And Mr. Basu has submitted a SCC online, Malad, copy of that 2022 judgment. It's not reported in Supreme Court cases as yet. Malad, I'll come back with the relevant paragraphs of that, where these three judgments have been followed. The three judgments I now cited, those have not been distinguished, those have not been overruled. And my lord, lastly, my lord, I wish to remind my lord, the options that are there before my honorable single judge, my lord, when coordinate bench has decided the issue this way or that. I'll come back next week.
Yes.
And I'll not address my lord on merits today. The only thing which was submitted by Mr. Basu on merits is that the judgment of
No, on merits you start first.
I'll first.
Yes. On the merit you will start first.
Today or the next day?
Next day.
My lord is taking out these matters only on Wednesday.
I'm taking your affidavit in opposition.
My lord has taken my bunch of judgments, and now those are mainly on merits. I'll come back with.
Can I get a copy of the judgment?
আমি তোমায় পাতাটা দিই, পরের দিন দেবো। তোমাদের জাজমেন্ট দাও আগে, আগে তো বলে দাও।
সেন্টমেরি তো আসলে আপনাদের কাছে
নেই গো,
তো আমি দিয়ে দিচ্ছি সাইটেশন।
ওটা জানি আমি, এখন তো পাইতে এখন জানি, আমি দিচ্ছি পাঠিয়ে দেবো। অবলাইজ।
Okay, you cover on 27. Come on 27. Wednesday.
27th. Not next Wednesday, no?
No, not next.
If my lord, there's some inconvenience on my lord's part, I'll come back.
27th, I know.
27th is a Wednesday. On Wednesday, 20.
Okay.
Yes, ma'am.
Please take down. The matter is heard in part. Place the matter on 27th September for further hearing. At 2 p.m.
The time for the service commission.
Item number
58.
8.
Item number 58, my lord. I'm praying for not this week, my lord.
You are for the petitioner.
Yes, my lord.
The mayor filed by affidavit in opposition.
You can. No issue.
But I am late by.
Let it adjourn for 2 weeks.
Sir, I am by all.
Let
You are for the.
I am for the Western.
Okay.
I am reading her.
Okay, okay.
Let the affidavit be application kept on.
Okay, please take down. An accommodation is sought for on behalf of the petitioner. Again, the matter is urgent today. This is the matter on 27th of September 2023. For hearing. Stop. The affidavit in opposition filed on behalf of the respondent number 3, 4, and 5 is given.
Did you have 2 more?
My lord, I am appealing for the petitioner, my lord. I am praying for not guilty, my lord. 59, I am praying for not.
You are for the petition?
Petitioner, my lord.
I am appealing for the unit. This one, 5 and 6. Fifty-nine one.
Make it not guilty, my lord. No, 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 no.
Not today.
I pray for not.
Very well, not today.
59.
59, not today.
Not today.
Item number 60, I appear filing my affidavit in reply.
I am for the respondent.
I shall be serving a copy of the affidavit in reply. I have not as yet served. I will serve it by today. But you kindly takes up the matter either 27th or thereafter.
Have you served upon them?
No, I have not. I shall be serving upon them.
Then serve.
Lordship, I shall serve. Kindly takes up the matter after the 27th.
You received the copy.
Lordship, this is Lordship, there are two affidavit in oppositions. One has been filed by IIST. I've already given my reply in that matter. This has been served, filed by the opposition has been filed by the Union of India. I'm serving my reply on them.
Affidavit in reply on behalf of the petitioner against the affidavit in opposition filed by the respondent number 5.
Lordship, that I've.
Okay, please take down. The affidavit in reply on behalf of the petitioner to the affidavit in opposition filed by the respondent number 5 is taken on record. Copy, sir. Stop. Let the matter appear in the list on 4th of October.
Lordship.
Forget.
My lord, 61 are for the petitioner. I appeal we have the university in this one.
Yes.
Here 5. We have served the affidavit in opposition. Yes, I have received a copy of the opposition, but I don't wish to file the reply because this is very short matter. But petitioner is an petitioner in 2009 appeared in the RET examination, that is in a research eligibility test examination conducted by the Vishwabharati for pursuing her PhD degree course in zoology. Petitioner duly qualified that examination, appeared before the viva and ultimately selected for the PhD degree course from the University of Vishwabharati.
Yes.
But what happened? Petitioner at that relevant point of time, petitioner is an employee of a school, particular school, which is why the university authority is seeking the NOC from his present employer. Petitioner duly applied before the school authority that I am going to going to join the PhD degree course, give me some NOC. I shall not hamper the school activities at all. My lord, it is the admitted position. I am not disputing it. Within 2 years, but candidate should furnish the NOC before the university authority. But ultimately, whether petitioner obtained the NOC from the school on 5th of May 2012, which is beyond the 2 years. 2 years. Now, my lord, petitioner after receiving the same in the May petitioner received and June it has been placed before the university authority. And petitioner duly canvassed that this is not fault of the petitioner at all because petitioner prior to apply. This is the technical issue. Petitioner may not get the NOC, which is at all not the fault of the petitioner. Thereafter, my lord, university authority communicated that they are regret to comply by they are regret to continue the PhD course because this is the far beyond the this is the policy against the university.
Now, my lord, this is the crux of the case. Thereafter, petitioner made several communication before the university, counter reply to the by the university, and lastly, from the there is a communication from the secretariat of the office of the governor that please consider this case sympathetically, because now the age of the petitioner is 45. If he at all complete this case, her age will be 50. He will not apply anyway he will not take the benefit of this course only for the higher education. Only for the higher education, petitioner is willing to continue at least its PhD degree course. And maybe your lordship may consider this is a special case since my lord, there is no fault of the petitioner, and let the petitioner be allowed to at least complete the higher degree. This is the my lord cut short of this case. I have nothing to say because it is admitted position. The NOC has received by the petitioner beyond 2 years, and there is it is also true that there is no fault of the petitioner. Since there's some technical issue, it has been, my lord, it has been goes down, and my lord, it has been also admitted, but petitioner requested the office of the governor to consider this case ultimately, who is the higher authority. But office of the governor secretariat made communication to consider this case sympathetically. However, my lord, it has not been decided yet. It is pending. That is all.
Yes, I beg to appear with the university. Well, I'll quickly request your lordship to go through the list of dates once. The petitioner has qualified for the research eligibility test on 23/3/2009. Thereby, the petitioner was given 2 years' time. That was sufficient enough to get an NOC.
Yes.
But we are here. The university is a statutory body. It's Vishwabharati University. We are governed by Vishwabharati Act.
No,
And
what prevented you to allow him?
because the NOC has to be submitted.
The NOC was not supplied.
And now the petitioner
within
has
2
filed
years.
this petition in 2022, my lord. Kindly consider that. This was for the year 2009. The eligibility test was conducted in 2009. He has to submit the NOC within 2012.
So you have to take a decision that
We have already taken this, and we have sent her a regret letter. I don't know why my learned friend is denying that.
She's not
No,
a regret letter has already.
There is a letter with it.
Everything is on record, my lord. They have tried to revive the cause of action by writing a letter to the governor. Now, my lord knows it very well. A government institution, whenever a letter is it is forwarded to a department where it should go. So, in that format only, it has come to us. But we have already, because the university is bound by its rule, it cannot open the as a special criteria after 10 years. For a research eligibility test, that too, because if this petitioner would have filed this case way back in 2014 or 15, the university could have considered this. Now the university does not have it has to again conduct each and every step. Either if he can qualify the research eligibility test again, then he's very much welcome.
Again, NOC would be required.
Definitely, he has to follow each and every step, Malat. How can we? Because it will open a floodgate then. We are a university at the end of the day, Malat. And and we cannot allow it, Malat. The research eligibility test was conducted in 2009. The process has completed in 2012. We have forwarded all the. If your lordship sees our affidavit in opposition, which is on record, we have forwarded her name for the interview process. Everything is there. If your lordship comes to page 17, that is a note sheet, Malat. It starts annexure C, Malat. Starts from page 16. It says a meeting of the BOS in geology was held on such and such date in the room of head of department of geology. Page 16, Malat, of my affidavit in opposition, which has been filed today. Annexure C.
Yes.
Malat, this meeting was held on 15/2/2009 at 2:30 p.m. in the room of head of department of geology. If your lordship comes to the bottom side, the following candidates were, has your lordship got it?
Yes.
The following candidates were interviewed for registration as they are RET qualified in geology. Considering their performance, they were recommended for PhD registration. Now, the names of the candidates are there. In column 5, Aparna Sarkar's name is also appearing, who is the petitioner herein. And then over the next page, Malat, at page 70, again at the bottom of the page,
It's written, since Aparna Sarkar is at present working in a school for application, her application is not sent in this lot. After she submits the release order from her school, it will be sent to your office. Therefore, I am endorsing 7 applications here. But now the university has given us sufficient opportunity to file an NOC. It's not that. So now we cannot go back and open the window again. It's a mercy petition. I understand that the career is at stake, but our hands are tied. Your Lordship has to consider that fact here, because we are governed by the regulations here. We have annexed the regulations as well, and now we cannot at it, because I also had a word with the registrar of the university, he has categorically stated that he will be unable to do anything in this case until unless an order of the court comes here. But that too will be it's a long drawn process,
No object certificate was given on 11th June of 2012.
Yes, madam. And it has to be submitted before 39/2011.
In the May, it has been issued and accepted by the university in the month of June 2012. Now, admittedly, NOC has given, and which is the record of the just far beyond the 2 years limit. My lord, only this, my lord, consideration, my lord, petitioners is a question of educational purpose. Petitioner may not apply the PhD degree anywhere, my lord, since the age of the petitioner. Only wish to complete the course for the hunger of the education. My lord, if your lordship, my lord, interest nobody's right will be prejudice, and petitioner may not, only for the purpose of educational purpose. A person only with this technical purpose can, I am putting this question to myself, my lord, can a technical purpose is right to education can be cut? My lord, only this question. Only for taking few days, my lord, few days after, my lord. So, my lord, now it is up to your consideration for, and the age of the petitioner is now 45. If it is presumed she will complete the case, the age will be 51 or 52. No, anywhere she may not able to use that degree for the purpose of the service purpose. Only for the educational purpose, she want to cease fighting in the court to establish her right. So, my lord, kindly consider this. This is a special case. Can it be?
She was sitting tight over her rights. Should have come to the court in 2014-15, something would have been done. We would have reconsidered the decision. We will be unable to do anything at this stage, to be very frank and candid.
Your lordship observe it and send it to the university for the reconsider the issue once again.
Your lordship can very well do that,
Observe.
I'm over to come in the way,
and sympathetically, and my lord, observe it on technical issue.
This is not a technical issue, This is something which is time barred.
Absolutely time barred. I am not denying it. I am not denying.
How many days delay is there?
There is delay at all. 19. So
30th September 2011 is the date.
Yes, and has been submitted on 11th June 2012.
Yes.
Yes.
And issued, my lord, by the school
Within
of
1 year.
Yes, my lord.
3 years.
Yes, so within 3 years.
Within
3 years. And my lord, issued when the school issued the same, my lord, subject to my lord correction, the NOC ought to, when I applied before the school, it is sent to the DI, district inspector, then DI send it to the board.
I understand.
Yes, when it's that that is caused the delay.
The difficulty is, we are in 2023 right now. Your lordship also knows it very well.
Deciding in the June 11, 2012. The issue is there. But why you not received on June 2012? This is the issue here. Now we are in 2023. I understand.
Yes.
But the issue
PhD
raised on the,
course, my lord, how can we reopen the whole thing for her? I mean,
No,
even
it can
it
be
will be a futile exercise.
I-
I'll to be very frank and candid, my lord, if your lordship sends it back, they will again reject it because they have ventilated their mind because they cannot do that. They're also an authority who cannot open a window again for a candidate, and that too after such a long period, my lord.
My lord, it is a
That is what I am mere creature, my lord. They have instructed me to tell this before your lordship.
yes,
And I'm just ventilating their thoughts here, my lord. Because they are bound by this rule, the ordinance which is here, my lord, which is annexed to the which says that now
Even, my lord, that-
this thing cannot be reopened, my lord.
My lord, even my rejection by that rejection by the university authority, they stated that this is they are regretful that they cannot continue. But my lord, they are not state way, but there is some technical issue. But there is no fault of the candidate. Even where there is no fault of the candidate, can, my lord, I'm putting this question to myself: can a candidate be deprived for the higher education?
yes.
And even if your lordship direct the university, they can do it because the sports is going on. It is not that it is a service that total chapter is closed. They can continue it. They can continue it because thereafter several communication made from my end and also from their end also. It is not that that is a limited seats of vacancy. That vacancy has already filled up. It's an educational purpose. No, which is it is.
Again, NOC will be required. Again, NOC after 3 years.
Yes. I'm sorry.
NOC, you again
Service.
wanting NOC.
Yes, my lord.
Yes.
She has to pursue her thing. That cannot be done because that is the procedure of law. Can she surpass or bypass is a procedure of law? I asked this question to myself, my lord.
Yes.
She has come up in 2022 with a writ petition.
My lord, kindly see my resolution of the school once, page number 16. It has been Bengali জেলা পরিদর্শক বীরভূম মহাশয়ের মাধ্যমে বিদ্যালয় এসেছে এই পত্রের পরিপ্রেক্ষিতে সহশিক্ষা অপর্ণা সরকারকে বিদ্যালয়ে দৈনন্দিন কাজকর্ম ব্যাহত না করে আংশিক সময়ের জন্য গবেষণা করার অনুমতি দেওয়া হবে। So it has been routed to the page 16. My lord, the resolution of the managing committee. Kindly, why the delay is caused? I want to put this. I want to making this point that delay is not caused by the petitioner at all.
Yes. I understand.
But what is the delay in filing the petition? How can they explain that?
There is several after one after
What
one
representations?
communication-
Malal, kindly
one
consider the
after
representation.
another-
Which representation my friend is
one
talking
after
about?
another communication is made from my end also.
The two which I can see here at page 19 and
2000
page 21, all in 2019, Malal. 29,
23
7, 2019, all in 2019. That is what I'm.
23 also.
Everything is on record. Malal.
23.
Everything is 2019, not
Yes,
before
yes,
that.
Not after that. And this is last communication.
Again,
from
she sleeps
20
3 years for her rights, and again she comes up in 2022 to file a writ petition.
2022, there is last representation. That is in page 24.
Very hard. Please take down. Not the matter claim. Let's see.
Offline. Wait. I'm offline.
Your lordship, on behalf of the petitioner, I'm playing for not today, your lordship. 62.
Not today.
Next one, step.
Lordship, I appear for the petitioner, my lord. Lordship, I'm led by Mr. Kolal Basu. Lordship, I'm praying for not today, my lord.
Affidavit in opposition. You have got the copy?
Yes, my lord. This, my lord, answering respondent is state of West Bengal, my lord. They have used their opposition, to which we have filed our
They
reply.
have filed it.
Yes, my lord. Next Wednesday. Reply.
Okay, please take down. Affidavit in opposition on behalf of the respondent number 6, UGC, is taken on record. The petitioner is at liberty to file affidavit in reply, if any, by the date fixed. Is the matter on 20th?
Deeply obliged.
In 64, I appear on behalf of the petitioner. A similar issue has already been heard by a coordinated bench and it had been made it CAV. So, my lord, can we wait for 2 weeks or 3 weeks so that we can get the judgment of that? Or, my lord, if your lordship may let the matter be go out the list for the time being, or may release so that we can, because this was going on before Jailot Justice Chandra.
Give me the affidavit.
ওখানে জাজমেন্টটা কিছু হলো তাহলে আর না হলে যদি বলেন go out the list for the timing তাহলে
Affidavit in opposition on behalf of the added respondent number 7, within bracket UGC, is taken on record.
ও কপি দেবেন স্যার কোথায় এটা দেন এটা দেন
Stop. The on submission of the learned advocate for the petitioner, the matter may go out of the list.
So this is not my submission, my lord. Therefore, I shall be difficult in future that I at my instant matter has been got the list. Since my lord, the already a matter has been hard and my lord the urgent
Let the matter be adjourned today. Let the matter be adjourned today. List the let the matter be adjourned today. List the matter after vacation.
After vacation. ঠিক আছে তার মধ্যে and my lord the liberty to be mentioned because
What is the liberty to mention?
otherwise my lord if we get the judgment we can mention before lordships or that this matter can be mentioned before that bench also. No, lordship
means the October.
No, lordship kindly, my lord, lordship kindly adjourn it and let it be the go out the list and liberty to mention. Then 3 weeks. After 3 weeks.
It will be appear after vacation.
No, after vacation, my lord, that's long.
3 weeks the vacation.
No, 3 weeks. No. এখন তো আজ কত? Today we are September.
Yes.
Let it be for 3 weeks adjournment, my lord. We shall get a chance so that if we get the order, we can place it before.
Last 2 weeks of the October, I will not be here.
Very well, my lord. Let it be after least after 2 weeks or 3 weeks.
Very well.
After vacation.
After vacation.
Matter is urgent till after vacation.
Yes.
It's 65 my lord. I am for the petitioner seeking not today.
Not today.
My lord.
Next.
66. I appear on behalf of the petitioner. It's a very short matter, my lord, which I should indicate to my lord. Now, my lord, certificate of disability was issued by the medical superintendent cum Vice Principal of Bardhaman Medical College, indicating that my disability is to the tune of 50%. That certificate had been attached at page 37 of the writ petition. Now, my lord, I appeared in the particular, my lord, before the authorities, my lord, which was gone through or which was done pursuant to an MCI notification which was annexed, and therein the disability which was shown is 11%. One disability certificate shows that I am having disability of 50%. Another disability certificate shows I have disability to the tune of 11%. Now, my lord, I was aggrieved because, my lord, I had appeared before the national eligibility test for, my lord, admission to the MBBS course. Yes. Now, my lord, it appears, my lord is well aware of, my lord, that under section 2R of the Persons with Disabilities Act of, my lord, Disabilities Act of 2002, my lord, the benchmark disability is 40%. Now, my lord, your lordships may kindly consider that I was aggrieved with this action. I came up before this honorable court, and, my lord, my learned friend had also appeared, my lord, in many matters. Now, my lord, several orders have been passed by this court for allowing, my lord, candidate, my lord, to appear in counseling. Now, truly speaking, today, my lord, what I am praying before my lords, that, my lord, the counseling has started. And, my lord, I am a candidate who had filed a writ petition in 2022. Now, it appears, my lord, that since, my lord, there was a direction for exchange of affidavits have been done in the meantime, and, my lord, matter has come up for my lord's kind consideration. Now, two things I have, which I should be very candid to my lord. My lord, since, my lord, counseling has started, if your lordship kindly takes it up on next, my lord, because your lordship had indicated, I was watching the proceedings, your lordship indicated that your lordship is taking up these matters on Wednesdays. Only on Wednesday. Now, my lord, I have two recourses open. Either, my lord, I may come to my lords, or having regard to the fact that, my lord, the counseling has started, and considering, my lord, it's only, my lord, a particular, which I should say, my lord, a career of a student, which, my lord, I can make a prayer before this court. Whether the court may allow, the court may disallow. I have also some orders of this court, which I will be placing before my lords, and thereafter, my lord, whatever your lordships will be. I say, my lord, kindly consider the fact that the counseling has started, and thereafter, my lord, whatever my lord decide, I have nothing to say, because my learned friend is appearing, and I cannot consistently, my lord, oppose him.
My senior friend knows, not any, that this counseling which is going on for the 2023-2024.
Yes.
The entrance exam is in 2023.
Yes.
This is the case where he had appeared in 2021.
Yes.
2 years back. Now he did not get admission. Now, apart from these factual parts, whether he is a disabled candidate or not, this has become academic. Because now, after 2 years, even if he is found to be disabled, he cannot be admitted in 2020. Nobody who has appeared in the entrance examination for this year can be admitted in this year. So really, this has become infractious. Your lordship, I would humbly submit that your lordship will hold that this is infractious and dispose of the matter. But if your lordship wants to decide the issue, it would be an academic issue. I can make submissions on that, because if your lordship sees page 38 once, this is the certificate which has to be taken into consideration. This is by the designated board of the central government for admission to medical colleges. Now, if your lordship sees, below it is heading page 38, your lordship has found.
Yes.
Certificate of disability. Now, after the details of the candidate, your lordship will find disability name specified locomotor disability
percentage of 11%. 11%, your lordship knows as per the Disabilities Act, benchmark disability has to be minimum 40%. 40% above only then the one would be entitled quota of the disability. He has been found 11% disability. And this is the only certificate which can be taken into consideration. There is no scope.
Yes.
Because this is
Miller,
Candidate.
Miller, I submit to my lords, Miller. It is easy, Miller, to non-suit the right of a person. But it is another thing to say that, Miller, because of the Persons with Disabilities Act, Miller, I cannot disown their particular, Miller, rights of, Miller, participation of a selection. Now, Miller, your lordship may kindly consider that the disparity of, kindly see, your lordship, Miller, had taken note of page 38. Kindly also take, Miller, the pains to come to page 37. This is also a certificate of disability issued by the Office of the Medical Superintendent cum Vice Principal. There, Miller, the percentage of disability, my lords may kindly take the pains to come to serial number 14, which shows that it is 50%. Therefore, Miller, this disparity of the particular disability, kindly see, has my lord got it, Miller, chronic neurological condition, and at page 37.
It would be better to decide the matter.
Yes.
That's the thing this is the only thing.
Yes.
Kindly come to page 38 once.
Locomotor disability.
Yes,
Not only
yes.
that, kindly see what is the board.
Yes.
This has come from where? Page 37 has come from Medical Superintendent come Vice Principal, Bardhaman Medical College. Now kindly see what is the board. Kindly see the three signatures. One is a professor, Department of Neuromedicine in the Bangalore Institute of Neurosciences. The other one is of IPGMER, the other one is of IPGM. The lordship knows what which is higher. And second one, your lordship will see at the top of page 38. This is as per the Medical Council of India Gazette notification.
Yes.
So it has to go through that. This is the panel. It has the Department of Professor of Neurology. It's the panel. And he says it is 11%. Then three of them together, one of orthopedics, one of neurology, and one at Department of PMR. I don't know what is the form of PMR, but it is also IPCM. Three professors and the head of the departments, including the neurology professor as well, that is 11% of the IPC area. The highest institution.
I understand. It has to be heard properly. Yes, yes. No. Yeah, no. Yes. Come on. Next one step. So I make it part. Okay. Please take down. The matter heard in part is the matter on 20th for further hearing. Two, only two. Yes. Okay. Not today.
Gratefully large.
68 and 69 are paying for the petitioner, man. But the writ petition is against a order passed by the registrar West Bengal University or West Bengal University of Teachers Training, Education and Administration and others. Alert. Actually, I am a settler who is running a college, that is Gauri Devi College. It is run by a trust where I am the settler. So the entire matter is related to a change of email ID, which leads to a disturbance in the administrative work. So we have made an approach before the registrar, who by a representation of the respondent have changed the email ID, and presently the original email ID of the college have changed by the university, by the instance of the university, and another email ID has been prevailing. So our hearing has been heard. My lord, kindly come to page number 97.
No, where is the university?
Answering respondent is university.
Mr. Amitabh Rai is appearing in this matter. He was also appearing. I don't know, means due to some difficulties, he is not present today. So challenging that order, we have come before this because the authority who have taken the the duty of the email ID is no more a party to the trust.
So where is the university? So come on next day.
My lord.
Come on next one step.
My lord, so the matter will retain in its position, my lord.
Yes, yes.
Obliged, my lord.
You inform.
I will inform, my lord.
You inform.
Hopefully, he will be there, my lord. Actually, this type of matter, some analogous matter are there related to the change of email ID, where the coordinate bench of this court, Honorable Justice Kaushik Chandra had adopted a procedure where they have appointed a special officer to take charges of this because the college cannot go in this manner because they are taking appointment, the college examinations are being going on.
Yes, yes.
So if there in two other matters, special officers have already been appointed. And by the consent of the university, we could adopt that.
Very good. Come on next one step.
Well,
Same point. Next.
My lord, in item number 70, Mr. Shoptangshu Basu, learned senior counsel is appearing. Lordship, I'm only praying for a nod today. He is engaged in another courtroom. Just a nod today, Lordship. Kindly takes it up next Wednesday as your Lordship written in the list.
You are for the six. Yes. Then the benefit to come. Now, thing is this not if matter is ready for hearing, otherwise ready for hearing. But only last occasion, the council for the central government appeared and thought of accommodation so that he can take proper instruction. Central government is Union of India is also a party, and representation by Union of India is necessary. So I don't find.
So who is representing?
Order. I find from the order because notice was served to the office of learned additional government, learned additional
Solicitor General.
Hereafter, engagement was done, and Mr. Avinash Kankani appeared for Union. Because his appearance is also very much required. Subject to the lordship's training. Because financially, they are seeking for higher pay scale. Petitioners are seeking for higher scale of pay. The central government is a necessary part. They have been made.
Mr. Avinash Kankan.
Yes. I request my learned friend who is appealing for the petition. Sir, the notice once again so that on the next notice the matter can be taken up. Because of the learned council for
My lord, I am not the advocate on record. Miss Mrinalini Mojumdar is. I believe she has some personal difficulty. If your lordship so directs me, I shall communicate the same to the advocate on record. Mr. Shoptangshu Basu, senior counsel, is appearing. Some personal difficulty, I think, is engaged in some court. Maybe taken up next Wednesday, lordship.
Is it possible within next Wednesday you can serve?
Lordship, I have no instruction.
Already time. I do not know whether he has already received instruction from the government.
Yes.
Because in terms of the order dated 30th March 2020.
So which time was granted 30th March.
Yes.
Now we are
so possibly
September. It would appear on the next week.
Lordship.
Very well. Please take. The Union of India is not represented. Stop. The petitioner is directed to serve notice upon the learned advocate for the Union of India appearing in this matter, inform the fact that the matter shall appear in the list on 20th of September. And all matter are true.
I'm deeply obliged, my lord. My lord, in item number 71, Mr. Oyun Banerjee is appearing on behalf of the petitioner. I'm praying for not today, your lordship. Some difficulty today. It may be taken up next week.
Not today.
I'm deeply obliged, my lord.
Yes, my lord. In this matter, I am for the petitioner, my lord. Swarup Banerjee appearing in this matter, Swarup Banerjee engaged in court number 6. Therefore, my lord, kindly take it on next Wednesday and fix the matter because it is very urgent matter, my lord. Several times we are suffering from this bench to others bench. From
This bench is assigned for hearing the matter.
no, my lord,
Start the hearing.
start the hearing, but I suffer from the Kaushik Chando and others bench, and several times I served the copy to the respondent authority, but they are not appearing.
Today they are appearing.
Only College Service Commission, but state not appearing. Arjun Mukherjee appearing in this matter on behalf of the state, but he is not appearing day by day. Therefore, my lord, kindly give me, kindly take it on next Wednesday. And
who is appearing for the state?
Arjun Mukherjee, already I served the copy to him, and 3 times already I served the notice. Arjun Mukherjee appearing on behalf of the state at present, because advocate change. Therefore, Arjun Mukherjee appearing. Tapan Kumar Dotto is not in the list.
Okay.
Tapan Kumar Dotto এখন নেই.
Earlier he was.
Earlier.
Pradot Kumar Das and Tapan Kumar Dotto.
But at this moment, Arjun Mukherjee. My lord, kindly fix that.
How can it be heard without their presence?
No, my lord, kindly fix on Wednesday. I will submit the notice to him. Press service করে দিচ্ছি.
Very, please take that. Learned advocate for the petitioner submits that the matter is pending since long, and if the matter is necessary to be heard urgently. Stop. The state is not represented. University of North Bengal is represented. 3 to 5. Respondent number 3 to 5 is represented, and the University of North Bengal is also represented. You are for the college. That is, you are respondent number 7. But University respondent number 7 is also represented. Stop.
My lord, take it on Wednesday 2 p.m.
The petitioner is directed to serve notice upon the learned advocate appearing on behalf of the state to the fact that the matter shall appear in the list on 20th. But is directed to get ready for hearing on that day.
But before your lordship, I just yesterday your lordship delivered the judgment, Lord, which I argued that 324 and 323 matter, Lord. Yesterday, Lord, it was item number 1. I was not present, Lord, when your lordship, Lord, delivered the judgment. The lordship, Lord, 324, your lordship, Lord, has set aside. So for 323 is concerned, Lord, when I argued the matter, Lord, this has felt from myself. Your lordship, the state has also not, Lord, disapproved. Your lordship was also, Lord, expressed your lordship mind. But your lordship, Lord, the judgment, your lordship has said.
323 is the.
Yes, Lord, but I was under, your lordship inquired from me how much I was in
many
custody.
days they are in custody?
So I was in custody for 15 days. So for 323 is concerned, the conviction was, Lord, 1 month.
No,
and
only 500 rupees.
No, Lord, subject lordship kind sanction.
No, only 500 rupees. It was ID 1 month. 324.
Did I make
just go through the record?
Lord, that is the reason, Lord, I was trying to mention, Lord, since 2.
No,
if it is 5,500.
5,000 rupees each ID 1 month.
Lord.
Yes, I am concerned.
Your lordship, then
yes.
Lord, because today, Lord, the when the matter.
I have indicated that only.
No, Lord, but he today, Lord, this was uploaded, and then, Lord, I got a note. But I have seen, Lord, the brief. I was also not carrying the brief, Lord. If it is not so, if it is otherwise, I'll trouble your lordship tomorrow morning. Double eyes, I'll come back. If it is not, then I will not
Yes,
come.
I have gone through the.
My lord, obliged.
It is the order of.
Whatever it is, I'll come back tomorrow morning and
Yes,
again I'll
you
apprise.
come back, you come.
My lord, obliged.
Usually the parted matter appear on the top. It is not the parted. Okay. You start hearing, then I can fix the matter. That's why I ask you to start the hearing.
আপনি দয়া করে রাত্রেবেলায়